for funding, I mean, you applied, bring that proof up here today or tomorrow or within 5 days, okay? And then we're going to give you that new date on July the 7th. Any questions? Okay, best of luck to you, man. Baldwin House versus Mr. Goodstein. Do you have any others?
Yes, I have two others at 9 o'clock, Your Honor, Bridgewood and Water's Edge.
Maybe I'm doing the 8:30 still here. Yeah, I'll get to those momentarily. Baldwin House, Chris Gross, 2502215.
Good morning, Your Honor. Timothy Procco, P59214, appearing for Attorney Butchart on behalf of the plaintiff, Baldwin House.
Good morning. The defendant is here and is approaching. Good morning, sir.
Good morning, Judge.
How are you?
Good.
Your name?
Chris Gross.
Did you listen to and understand the rights?
I did.
You wish to speak to a lawyer?
I'm dealing with the Volunteers of America. I'm on a housing voucher because I'm a homeless veteran. And the whole problem started here is when I got out of the hospital and May 4th over at Wyandotte. I come home and my apartment was broke into. So they stole my money. And I showed the manager, Tanya, I don't know her last name, what happened to my apartment. She's like, oh my God. So.
Did you make a police report?
They got everything right there. And I just haven't had the money to go get it. But,
to get money to go get what?
Police report.
So you did file a police report?
They have a police report ready for me. The Brownstown Police.
Did you call them?
I live right by there.
No, listen, I want to make sure. I think we're talking a little about the same language, but I don't know. Did you go into the police station and make a police report?
No.
Did you call the police station and make a police report?
No, I don't have my phone. I go over.
All right, slow down.
Okay.
So there's been no police report filed, correct?
They said they have one. They told me to come pick it up.
Did somebody from Baldwin House file a police report?
I'm not aware of that, Your Honor. No, I don't believe they did.
So if somebody broke into your unit and stole your money, you should make a police report.
Right.
You should have done it then.
Well, see, then I had to go back to the hospital again, and I was in there I got home on the 21st of May to take care of business, and I got to go back to have a couple surgeries.
Okay, let's go back on track here. Do you want to speak to a lawyer?
No, I can't afford it.
We'll give you one.
Okay.
You want to speak to a lawyer?
Yeah.
Did you apply for, or do you intend to apply for funding?
I do.
Your Honor, this is a termination case, just to clarify for the record. It's not a non-payment case.
I see. Thank you. I always make this assumption.
No problem.
Dad used to tell me not to do that.
I understand you got to do your rights. I get it. I just want to make sure that we were clear.
So, do you have a place to go?
No, not right now. I could probably go back to the shelter, but I'd have to find out if I got room. Or I could just live in my car.
Slow down. I don't want you living in a car. But
my voucher's still good. I can go down to the voucher.
yeah, but they're terminating the tenancy.
Okay.
Okay. Did the lease expire? Is that what happened, counsel?
No, it's basically based upon Mr. Gross's behavior, multiple incidents of behavior. There have been police reports filed as a result of his behavior, but I'm not aware of a police report with respect to the damage.
So contrary to rules of the landlord.
It's a lease violation, Your Honor. Yeah, lease violations.
So, look, I still am going to give him the opportunity to speak to an attorney.
Understood.
But applying for funding isn't going to help you here. That has nothing to do with this case.
Okay.
Okay?
I tried to work with management and tell them that I would make payments.
It's not about money.
Okay.
They're saying you're violating the lease provisions.
Okay.
Okay? And it has nothing to do with money.
Well, my lease isn't up yet.
Well, I understand, but they're saying you violated lease provisions.
Okay.
And you said specifically, what did he do, Mr. Prochko?
Well, there's a laundry list, Your Honor, if you will, dating back to early April. There's been multiple events about his run-ins with other tenants, how he's treating them. He's screaming and yelling at people. He's been abrasive toward management. He's caused damage to
Caused
the
damage to
premises. There was a water machine or something that he damaged back on April 9th and 10th. He's yelled racial slurs at a maintenance supervisor. He's had run-ins with multiple staff members. He's threatened other tenants to blow their head off their shoulders, quote. And that was the subject of a police report, Your Honor, Brownstown Police Report 258947. There was another incident where some of the tenants alleged that he threatened harm to them, which is Brownstown Police Report 258940. So there's been 6 or 8 incidents here, Your Honor, and that's the general basis of the lease violations and termination.
Are you talking to a counselor or anything?
No,
Do you drink?
I do.
Were you intoxicated maybe when some of these things happened?
This is all.
I'm asking you, were you intoxicated when some of these things happened? If they happened, did you threaten to kill people?
No, not at all.
Did you make racial slurs?
I might have.
Well, why would you, listen, there's no place here.
I understand, Judge.
There is no place.
I apologize.
Well, you can't do that. You can't threaten people and you can't make racial slurs. Stop. Listen, I have the utmost respect for anybody who served in the military. I really do. I really do. It breaks my heart to see somebody that's this old, you got a cane, but you can't do that. I'm serious.
Well, I apologize.
Well, it's not good enough. You can't do that. It's like the guy who robs the bank and says, I apologize when he gets caught, or beats up his wife, or goes and kills somebody. I mean, no. It's not good enough.
All right, I understand. I'll get help. But I'll go back to the shelter.
I'm going to adjourn this 1 week so you can speak to a lawyer.
Okay,
I'm setting this on June the 23rd.
okay.
Your Honor, is that formal hearing or is that another pretrial?
Just another trial.
Okay.
I have a feeling you guys can work it out. June 23rd at what time?
10 o'clock, Your Honor.
10
And
o'clock.
we did give you that packet to your,
What's this?
that is the termination complaint. I apologize. I didn't have it printed,
Okay.
just so you had it.
Come on. Come on.
I understand.
Come on. I mean, we're going to put you in a breakout room to speak to one of these lawyers. I just don't understand the anger and hatred in this country anymore. My Lord, we're supposed to be on the same team.
Can I speak for
No. No, go talk to the lawyer.
All right,
And then June 23rd, you come back here.
all right.
So he's going to set you up. They're going to set you up with a caseworker. You make sure you make that call in the next day or two so you're ready to proceed on this next week. Okay?
Okay.
Thanks.
Thank you, Your Honor.
Thank you. Do you have any more, Mr. Prosco?
I do for Marsh Creek, though, Your Honor.
All right, I'm going to go. I know I asked you guys that. I'm going to take that one next. I'm going to quickly take this Stephen Church. Stephen Church. 24B147140, Stephen William Church, 24B147140. Mr. Church, your name?
Stephen Church.
You got to start your video, sir.
Oh, can you see me?
Yeah, I can
Hear me?
now. Your name?
Stephen Church.
All right, so I'm trying to be patient. I told you to pay 40 a week beginning beginning April 18th. And I also told you to call the court and go on Zoom with me or come in here, Your Honor, before that due date if you need an extension. Here we are 2 months later, so I'm going to let it go. But when I give you a payment plan, you have to pay or at least talk to me on or before that date. Fair?
Yes.
I think so. I mean, I don't think a lot of judges offer that. So let's show a little bit of respect. When can you start to pay your 40 a week?
I go to my doctor today to see if I am able to go back to work or I'm still going to be on medical. I broke my hand in January and I had
All right,
surgery
you
on
were
my
in front of
hand.
me in February, so we would have covered all that. So let's pick a date with the understanding that you're going to start to pay, or you're at least going to give me the courtesy of calling the court and going on Zoom or coming in here on or before that date, and I'll be happy to work with you. So give me a date in the future when you think you can pay your 40 per week.
Can I do a month from now?
Yeah, but you got to talk to me next time earlier, okay? We'll
Okay.
start this beginning July the 18th. You don't have the money July 18th. What are you going to do?
I'm gonna come in for a Zoom.
Or you're going to call the court and we'll get on Zoom like this. 40 a week starting July 18th. Good luck. Thank
All
you.
right.
Marsh
Thank you.
Creek versus Quanche Dix, 2502217.
Good morning again, Your Honor. Timothy Procco, P59214, appearing for Attorney Butcher on behalf of the plaintiff, Marsh Creek.
All right. Is Quanche Dix here?
No, Your Honor, I've not had them checking in Zoom.
And it looks like they paid for a second mailing. You can go ahead and proceed with a default judgment.
Your Honor, we would request entry of default judgment for possession only. Rent to retain is $1,649, 2 months of late fees at 70 each for 140 total. Costs of $170 for a total judgment amount of $1,959, requesting a writ date of Thursday, June 26th.
Defendant failed to appear. The relief requested will be granted. That is a default judgment of possession in favor of plaintiff and against defendant. Writ date will be June 26 to 25, 1959 is the amount to be paid to save it. Marsh Creek versus Richard Jones, 2502219.
Timothy Procco for the plaintiff.
Mr. Jones, good morning. Your name, sir?
Good morning, Richard Jones.
Mr. Jones, did you listen to and understand the rights?
Yes, I did.
And do you wish to speak to a lawyer?
Yes, I would like to try to get assistance.
Do you intend to apply for funding?
Yes.
All right. Here's what I'm going to do. I'm adjourning this out 2 weeks. You have 5 days to come in here and provide proof that you've applied for funding. In the meantime, listen, just look at me.
Yes.
Okay, just stay right there, please. I want to see your face. Okay, so you're going to apply for funding and you have to provide us with proof that you've done so by bringing up proof within 5 days. You're
Okay.
also going to stay there. We're going to set you up to speak with a lawyer, okay? You're going to
All
have
right.
to, you're going to take some information and then you're going to call back Lakeshore in the next day or so, so you've had a chance to speak with them before the 30th. Actually, counsel, I'm sorry, I have to make this July 7th again. He's entitled to 2 weeks. July
That's okay.
7th at what time, Gene?
10 a.m., Your Honor.
10 a.m. All right, so stay right there. We're going to put you in a breakout room.
All
And
right.
then you call them, the Lakeshore, in the next day or two. You're going to speak to a caseworker, okay?
All right. Thank you.
Best of luck. Thank you. Marsh Creek versus Tamika Jones, 2502220.
Timothy Procco for the plaintiff, Your Honor.
All right.
Hello,
Good morning, ma'am. Your name?
Tamika Jones.
All right. Did you listen to and understand the rights on the video?
Yes, sir.
Wish to speak to a lawyer?
Yes, please.
Are you applying for funding?
No, I just need until Monday to pay it in full.
Okay, we'll give you a week. You're going to stay right there. We're adjourning this to June the 23rd at,
June 23rd would be 10 o'clock as well.
at 10 a.m. So, ma'am, you're going to stay right there. They're going to set you up with a caseworker from Lakeshore, and then you make sure you get a hold of them in the next day or two, okay?
Okay, thank you.
I'm adjourning it 1 week from today, June the 23rd at 10 a.m. Best of luck.
Thank you.
Marsh Creek versus Angelique Lawrence, 2502221.
Timothy Procco for the plaintiff.
Do you see Ms. Lawrence? There you are.
Yeah.
Yes. Good morning. Your name?
Angelique Lawrence.
Good morning. Did you listen to and understand the rights, ma'am?
Yes.
All right. do you wish to speak to a lawyer?
Yes, I do.
Do you intend to apply for funding?
Yes, I definitely do.
How much is owed on this, Mr. Prochko?
Current total amount is $5,988, Your Honor.
You gonna be able to pay that, ma'am?
Yes. I work 2 jobs, midnights at a hospital and at the doctor's office during the day.
All right, so we're gonna need proof that you made an application for funding within 5 days, okay? Within
Okay, I
5
can-
days, you have to bring that here. We're gonna put you in a breakout room to speak to Lakeshore, and then you'll have to follow up by calling their lawyer in the next day or two. And I apologize, counsel, I have to adjourn this until the 7th at
10.
10 a.m.
All right,
Okay,
thank you, Your
ma'am?
Okay.
So you understand? Do you have any questions for me?
So far, no. I just hold
Okay,
up
so-
and talk to the lawyer in the breakout, correct?
You're going to speak to a caseworker, and then you're going to follow through with calling the lawyer. They're going to take all your information. Then you have to provide us with proof that you've made your application for funding within 5 days.
Okay, will do.
Okay? Any other questions?
No, sir.
Good luck. Marsh Creek versus Jocelyn and Agnes Niemi, Niemi, file 2502233. Good morning, ma'am. Your name
Jocelyn Amy.
is Agnes
she-
with you by chance?
She's my co-signer. She doesn't live with me.
All right. Did you listen to the video?
Yes, sir.
Did you understand the rights?
Yes, sir.
Do you wish to speak to a lawyer?
Yes, sir.
Lakeshore is going to be busy today. Do you intend to apply for funding?
Yes. And I also had a question.
Wait a minute, let's slow down.
Okay. Okay.
How much is owed on this one, counsel?
$1,869, Your Honor.
You going to be able to pay that, ma'am?
Yes.
Okay, what is your question?
On my paper it says something different, but you just said a number that I'm good with, so that was fine. My paper said 3,000. I was wondering where the extra 1,400 was coming from, but it's all good now.
All right, so you're going to stay where you are.
Okay.
Lakeshore will set you up in a breakout room, and then you have to follow up with the lawyer. You have to provide us with proof that you've made an application for funding within 5 days. Do you understand that?
Yes, sir.
All right, I'm adjourning to July 7th at 10 o'clock. And you have to follow through again. Wait right there. A caseworker, I think, will come on and speak with you, take your information, then you call
Okay.
Lakeshore in the next day or so. And then make sure you submit your application for funding within 5 days.
Okay.
Any questions?
No.
Good luck to you, ma'am. Marsh Creek
Thank you.
versus Ashley O'Neill. You have to start your video, please. 2502224. Your name?
Ashley O'Neill.
Counsel,
Timothy Procco for the plaintiff.
did you listen to and understand the rights, Ms. O'Neill?
Yes.
Do you intend to apply for funding?
No, I just need 2 weeks to pay it in full.
Do you intend to speak to a lawyer? Would you like to speak to a lawyer?
Yes, please.
You think you're gonna be able to pay this within 2 weeks?
Yes, for what I have, I turned in 1,600, and the remaining, I believe, was 19.
Is that
It's-
right, Counsel?
It's 1941 rent, 170 with costs for a total of 2,111. So it sounds like we're on the same plane except for the costs.
Okay, what do you want to do? Do you want me to adjourn it for just a week or 2 weeks and see if she comes up with the money?
Well, let's do a week. You're not here in 2 weeks, it sounds like. So
Well,
maybe let's do a week.
I'm hearing next week and the week after, but I'm not. Oh, wait a minute. No, I'm not. Jeez.
Yeah, just next week.
Yeah, so.
Maybe a 1 week adjournment, Your Honor, if that's
Yeah,
good
we'll
with you.
adjourn this. Sorry.
That's okay.
We'll adjourn this to June the 23rd. And what time am I giving them?
10 o'clock.
At 10 o'clock. Ma'am, you wait right there. We're going to set you up with Lakeshore. and then they'll take your information, then you have to follow up with a phone call in the next day or two, okay?
Okay, and then you said 1 week, but is it possible it can be 2 weeks?
I'm sorry?
You said 1 week, but I just said I needed just 2 weeks to pay it in full. Am I only able to get 1 week?
I'm not here on the 30th is his problem, see?
Okay.
I'm not here until the 7th.
Okay.
So why don't you see if you can pay some of this next week?
Okay.
And then I could, maybe they'll go along and maybe with another adjournment or a conditional dismissal or something else, okay?
Okay.
Yeah, I think it's possible. I mean, we can obviously work with Lakeshore on an agreement prior to that, or we can work
Right.
through that, Your Honor.
Thanks a lot. Good luck to you, ma'am. Wait
Thank you.
right there now.
Okay.
Marsh Creek versus Tyasia Pool, 2502225. Good morning, ma'am. Your name?
Aisha Poole.
Did you listen to and understand the rights?
I did.
Do you wish to speak to a lawyer?
No, I'm okay.
Do you intend to apply for funding?
No, I just need 2 weeks to pay it in full.
I'm sorry?
I said, no, I just need 2 weeks to pay it in full. I can pay
What is
it.
the balance on this, Mr. Prochko?
$1,853, Your Honor.
What do you want to do? Adjourn a week or?
Yeah, that's fine.
We'll adjourn this 1 week to the 23rd, see what you can come up with, okay? And then if you can't pay it in full, maybe you and Mr. Prochko can go into a breakout room next week and talk about it. This is 10 a.m. again, Jen?
Yes, Your Honor.
10 a.m., June 23rd. Okay, ma'am?
Okay, thank you.
Any questions?
No, I'm okay.
Thank you. Good luck. Marissa Roberti. This is Marsh Creek versus Marissa Roberti, 2502226.
I've
Timothy
not had the
Bracco for the
defendant check
plaintiff.
in.
I'm sorry.
She didn't check in?
She did not.
You can proceed with a default.
Your Honor, we would request a default judgment for possession only. Current rent to retain is $7,819. There are 5 late fees at $70 each for a total of $350. Costs of $170 for a total redemptive amount of $8,339.
Defendant failed to appear. Default judgment's entered. Writ date will be June 26th of 25. The writ date in this case will be that date, and the amount to be paid to save it is $83.39. Marsh Creek versus Daja Thomas, 2502227.
Timothy Bracco for the plaintiff.
Hello,
Good morning, ma'am. Your name?
Deja Thomas.
Did you listen to and understand the rights?
Yes,
You wish to speak to a lawyer?
yes,
Do you intend to apply for funding?
yes.
How much is owed on this?
The ADSAP program in Augusta or the Wichita.
Jaleesa McDowell.
Allie Zend on behalf of the people, Your Honor.
Rob Brown on behalf of Ms. McDowell. Ms. McDowell, can you state your name, please?
Jaleesa McDowell.
All right, this is the people's motion.
Thank you, Your Honor. Your Honor, at this time, the people would request the court set a bond of $50,000 cash surety. I'm aware it's already set. In this case, the people originally requested a $100,000 cash surety bond, and the magistrate granted a personal recognizance bond at the arraignment. This case stems from a 911 call from the victim's friend after she received a text from the victim saying that her mother had stabbed her and that she was scared to call 911 because the defendant had been threatening to kill her if she heard sirens. When officers arrived, they spoke with the victim, who informed them that she and her mother had gotten into an argument. And from that argument, the defendant grabbed a butter knife and stabbed a wall in the house and then stabbed the victim's hand. After stabbing the victim's hand, the defendant then forced her into the bathroom and yelled at her to take off her clothes and get in the tub. The victim refused, and this caused the defendant to then grab her around her throat, shove her into a wall, which caused her head to hit the wall. The victim informed officers that she was extremely afraid of her mother and fears that her mother will kill her. And the people have extreme concerns given this case and the fact that the victim had to go to the hospital for that stab wound that required stitches. We have extreme concerns for the victim's safety as well as the community's. This defendant also has another case that was recently charged, and I believe was arraigned on Friday for an MDOP against her boyfriend. That case stems from incident in March of this year where the defendant chased her ex-boyfriend in a car and was throwing rocks at his car while it was driving down the road, resulting in damage to the vehicle. So at this time, the people would ask that the court set the bond at $50,000 cash surety in the GBHFA case and believe that the personal recognizance bond was an abuse of discretion, Your Honor.
Thank you. Your Honor, I've had the opportunity to meet with my client prior to today's hearing. I wasn't present at the arraignment, so I don't know what facts were argued by the prosecutor's office. The only thing new that I'm hearing since the bond was set at personal recognizance by the magistrate on June 12th is the authorization of the malicious destruction of property charge, a 1-year misdemeanor, which my information is involved rock throwing. It did not involve the complaining witness, her 15-year-old daughter. It was a separate incident in March. So I don't know what information is new that is being presented to this court. As background, my client has 2 children that are in the household, a 12 and a 13-year-old who are currently, and I stretch to say unsupervised, but I think they're in the care of neighbors and friends, and they need structure as school is out right now. My client is gainfully employed at the mobile gas station at Haggerty Road and I-94, where she's a supervisor. Also, when she was arrested, her home was not secured, and her home right now, as I understand it, is unlocked, and people are helping themselves to the contents of her home. She lives at 1243 Stamford Court in Ypsilanti, 48198. And it's my information that the prosecution has not been provided or has any jail calls where my client has made any contact or had any contact whatsoever with the complaining witness. And as the court's well aware, had they been armed with this information that my client was attempting to reach out to her 15-year-old daughter, they would have presented to the court. So boiling this all down, we have no new information other than the rock throwing incident, which occurred in March. I'd ask the court to consider a $5,000 10% bond. The prosecutor, I believe, told me that the bond for the malicious destruction of property charge that was authorized and that my client was arraigned on was set at $1,010%. And also as a condition of this, any release, this case, the instant case, any release would include release on a GPS tether. So we would have, the court would be aware of where she is at all times. And it's my information that the complaining witness, her 15-year-old daughter in this case, is not in the household. So there would be no problem with any unwarranted or any contact whatsoever. But my client needs to get out to save her job, help in the defense of this case, secure her home, and secure those 2 minor children that aren't in school. So I'd ask the court to consider a $5,000 10% bond.
Well, I thought that the other children, as I was understood, were with, that their, I guess, care had been secured.
That's my information. I have not been able to verify it. Counsel that was assigned the case this morning called off, so I went to the jail and did due diligence as required by MIDC standards to meet with my client. I can't speak because on verifying that where those children are right now, but that's my information that I don't know their supervision right now. I haven't been able to ascertain that because I had to go see my client, but I got the call from my colleague who called off.
Well, just so that we're clear, I watched the arraignment after receiving the motion, and my understanding was that the 15-year-old was with her grandmother.
Your Honor, per my notes, the other minor children are staying with the stepfather, and then the victim, the minor child, is staying with her grandmother. And then further notes indicate that the children were put with a brother or girlfriend who lives either near, next door, or close to defendant's residence. So I'm not exactly sure at this time where they're staying. I know they talked with CPS, who is working on getting the grandma to be the caretaker at this time.
Okay, that was one of my questions, whether or not CPS was involved, but.
And that's another concern of my client, not to cut you off, Your Honor, but with the tenuous supervision, as stated by prosecutor as well, there is a plan in place, but I don't know, kids being kids, I don't know how manageable they are. You've had 12 and 13-year-olds, Your Honor. You can't even get them to go to turn off the TV sometimes or come in when the street lights are off. You know what I'm
I don't
talking
know how
about.
your kids act.
Oh,
That was not my children.
oh, okay.
All right, so, but Ms. Zenda, these new individuals, I'll call them, that these children are staying with, does that include, at least based upon what you have, that the victim or the 15-year-old is there?
I believe so.
I heard a grandmother in Detroit. That's what I thought I heard.
Well, that initially was where she was going to be, but the other two were supposed to be with, I thought, at least as what I could understand from the arraignment, we're supposed to be with the father of the middle child. But now I'm hearing something different where all three children may be someplace in the same neighborhood.
I believe so. We received an email from DHHS that said the kids were with an Alicia Clark, who is the defendant's brother's girlfriend, and the residence of the address that they're at is, can we approach, Your Honor?
Yes.
Hey, everybody, want to jump in and say thanks for coming in this morning. We've got a Judge McNally hearing I was waiting for today, so we'll probably be jumping back to Judge McNally pretty quick. Let us know if there's anywhere else you want to go. Right now, Judge Simpson is where it's at, so let me know and keep the comments coming. Thank you.
Like at a brief press conference, and the major subjects of the clear was the at least the last known address regarding the children that are involved in the case been put on record. That way, was there anything else from my other side?
Nothing from the people, Your Honor.
No, Your Honor, other than she needs to get out take care of those kids. The two that the two that she can have contact with, keep her job and.
Well, and maybe that raises another concern for the board. I became aware of the MDOP after, or at least the details of the MDOP after the court had made its initial decision regarding the magistrate setting a bond. But why should I permit, given what I hear, her to have any contact with children or anyone under the age of 18?
Because CPS will step in. And then that's a whole nother can of worms.
What is a whole nother can of worms?
CPS investigating and possibly.
Correct. But typically in cases that might be similar to this, where there's injury to a child, we don't, the bond conditions are set where there is no contact.
With any children?
With any children.
If you let her out, we don't object. Put her on a tether and set her bond at 5,000, 10%. No objection.
Okay, but then I have the other issue that if she were let out, the location, at least as known, of the children are in very close proximity to where she would need to reside, which is my other concern.
She's already got a condition for release on a tether, so you know where she's at.
I don't know that it's much of an issue.
I can get another address, sir.
Okay. Don't interrupt the judge.
I'm sorry.
The concern that I have is it's not a home confinement tether. It is just an exclusion zone, which, given the addresses given, the children would be residing within that exclusion zone.
Understood. She said she'd give you another address.
Well, I don't know anything about that. I mean, maybe she should have talked with counsel about that.
Well, we don't know where the kids are. To see if there's going to be any violation.
I know, and I understand that, but I also know that as of Friday, or at the time of the arraignment, one child was one place, the other two were at some other location with someone. Now I get here today and am told that all three of them may be someplace else. Now, granted, on Friday, I did not have any information or any indication that CPS was involved. I was going to imagine that they were going to be, but I didn't have any of that information. So I don't even know where these children are at this point.
And that's why I said CPS involvement. She's fighting this case and now she got to deal with CPS too.
Well, I don't know, right? I mean, I can't say anything about what CPS will do or not do. I just know that. All right. The magistrate in setting the bond, there were a couple of things that the motion indicates, and from what I'm to understand, that there were indeed threats that were made to at least the victim in this case, the 15-year-old. Both from what the court understands before and after the incident of the stabbing or the injury to the 15-year-old's hand. The bond form, the law enforcement bond form, which may have mistakenly misled the magistrate, indicated that there were no threats. However, there were indeed, or at least there were indeed threats. The other concern that I have is that there is a weapon that is used against a minor not just in a threatening or assaultive fashion, but in a fashion which then indeed led to the injury and the necessity for medical treatment of that 50-year-old. There's further the indication that the defendant or that the victim in this case is fearful of the defendant. In looking at just those facts, the court would find that the bond as set by the magistrate does constitute an abuse of discretion with reference to a PR bond, and then simply without knowing the exact location of GPS involvement, just a GPS with an exclusion zone and nothing more. So the court does find that that's an abuse of discretion. Knowing additional facts, and let me just say this, it's an abuse of discretion because of the alleged conduct of the defendant in this case, and that the court would consider that the defendant would then be a threat to not only the victim in this case, but a threat to the community, and a monetary bond, given those circumstances, should have been set. As we now sit here today, there is the additional information regarding this defendant and alleged activities of violence toward someone else with the malicious destruction of property claim, or malicious destruction of property circumstance. From what I am to understand about that case involves either a boyfriend or ex-boyfriend. There is a concern that the court has, given that I have 2 domestic violence incidents by this defendant, allegations or cases that are domestically involved, which raises additional red flags for the court, and also a heightened belief that the defendant in certain circumstances does indeed pose a risk to the community. Taking all of that into account, I'm going to do 2 things. I maintain the bond that the court originally set, although quite frankly, I believe that I should raise it. And that bond will be, her bond will be set in the amount of $50,000. That's a cash bond. Further, the court is going to order the cancellation of the exclusion zone tether, but should the defendant be released, certainly I would reconsider it, but I would order a home confinement tether as a condition upon her release, prior to her release, should she postpone.
When's your next hearing on this one?
Pardon?
The PCC is already set for June 26th.
PCC is June 26th.
If we get you a new address, would you reconsider before then? Or
Reconsider which portion?
a 10% privilege?
I will certainly look at anything that anybody presents to me. I'm disinclined to change anything until I have some information regarding where the alleged victim in this case is, as well as these 2 other children and where they are. But at this juncture, I'm not inclined to change it.
Yes, sir.
All right.
Yes,
Thank
sir.
you.
Thank you. I'll see y'all tomorrow.
Yes, sir. 14A in recess.
How you been, Judge?
I'm always good.
I know you are.
He's been paying, but the other guy right over there has not. And every time I try to collect
of $101, those are less than $70.
That's your name, sir?
he's 84.
About this, I really am. Good luck.
No worries. We'll see you next week.
Okay, owner's management. Your name, ma'am?
Brianna Garland.
Good morning, Your Honor. Attorney David Lechner on behalf of Owners Management.
Is Cynthia Garland somebody different, or is that you? It says Brianna Cynthia Garland.
Cynthia Garland is my mother, and she is in the ICU down at Harper Hospital in Detroit.
I'm sorry. I wish you well and her well, of course.
Thank you so much, Your Honor.
Let me read this. I had a hard time reading this motion. It says, missume on June 2nd only due to me being with my mother who's been in and out of
The
ICU since mid-March. Sent out $480 money order on May 30th like Judge asked. Like Judge asked? Did I ask?
Yes, you did, Your Honor.
Your Honor, if I could give you some background on this matter. So we met on the original hearing was, I want to say it was the last Thursday in May. I think that was Thursday, May 29th. We agreed to an adjournment to June 2nd if Miss Garland paid the rent that was due and owing. It's my understanding through talking to Miss Garland and speaking to my client that she put a check in the mail or a money order in the mail on May 30th. And then didn't show up on June 2nd. My client didn't receive the money until June 9th. So on June 2nd, when no one was here on behalf of the Garlands and no money was received by my clients, I asked for and received a default judgment in this matter, which I promptly filed and was entered that day. Ms. Garland called me after getting the default judgment in the mail, told me that she had sent the money. I don't remember what day that was, but eventually I found out that my clients received the rent on June 9th. There was still other money due and owing, which has been since paid. And then Ms. Garland filed this motion to set aside the default. After speaking with my client, speaking with Ms. Garland, all the debts have been paid. We're fine with setting aside the default and dismissing the matter.
So I'm just going to indicate, I don't want to put words in your mouth. Default judgment set aside per agreement of the parties and case dismissed, right?
Correct, Your Honor.
Will you submit the orders to that effect so we can get rid of this case today, please?
I will.
All right, good enough. So he's going to submit the order, setting aside the default judgment and dismissing case. And you agree with that, right, Ms. Garland? Everything he said?
Yes, sir.
I wish you well. Good luck to your mother, huh? Good luck.
Thank you so much.
Have a great day. Good luck.
You too.
Owners Management versus Kyra Graham, 2501942.
Morning, Your Honor. Attorney David Lackner on behalf of Owners Management.
Is Kyra Graham here?
She is. She was. I spoke with her in a breakout room.
Yeah, she was. I don't have her any longer in my meeting.
Is she still in the breakout room?
No, I've just checked all of those.
Do you have her phone number by chance, Mr. Lechner?
I do. No, yes, I do have a phone number for her.
Why don't you call her up and tell her to log back in, and I'll go on to another case. How's that?
I will do so, Your Honor.
Thank you.
Yep.
Nicolette Marie Porter, 25B148287. All right, your name?
Nicolette Porter.
All right, next time you got to come talk to us earlier, okay?
Yes, my vehicle broke down.
All right, how much do you have today?
I have $40 today.
All right. Can you pull her up, please?
Sorry, they've been sending all my mail to Kentucky and stuff.
Kentucky?
Yeah.
Beautiful state.
I lived in Kentucky for about a year and then I just came back, so I didn't even switch everything over yet.
All right, let me just check something here. You owe $198 on this. You can pay $40 today. Where do you work at?
I was doing Instacart.
Okay, tell me when you can pay all of this. I can set you up on a weekly plan, bi-weekly.
I should be able to do weekly or bi-weekly or weekly.
Of how much per week?
Per week, I know I can guarantee 25.
All right, good enough. On Mondays, Fridays, what?
That doesn't matter.
You pay $40 today, $25 per week, beginning June the 23rd, okay? If you don't have the money somehow, I get it, it happens. Just call the court, we'll go on Zoom on or before the due date, or come in here on or before the due date. Glad to work with you, okay? Just don't ignore me, all right? Okay, I don't like that. Good luck. Wish you well. Thank you. Williamsburg versus Stephen Rowland, 2501959.
Good morning, Your Honor. Rebecca Austin for plaintiff.
Good morning, Ms. Austin. Mr. Rowland, your name?
Stephen Rowland.
Did you apply for funding?
I did.
Did you hear anything?
Actually, they were supposed to call me back today, and I was just told where I was supposed to file my proof of application for funding.
Did you provide proof that you made application for funding with the court?
No, not yet. That I was just informed about where to do that at.
Wait a minute. You got to get closer to that device. I'm having a hard time picking up your words.
I was saying I have not filed my proof of application with you guys, but
I told you you had to do that within. I told you you had to do that within 5 days.
No, I know. I wasn't sure exactly.
I can't hear you. Sir, I cannot hear you. You got to get closer to that device.
Oh, I'm sorry.
You did not you did not submit an application or provide us with proof that you submitted an application for funding, right?
Yeah, no, not yet.
And did you hear anything from them?
Not yet. They were supposed to call me back today.
All right, counsel, what do you want to do?
Ron, I'm happy to give them a 2-week adjournment to work through the
I'll
process.
adjourn this to June the 30, but you got to bring that up here, sir.
Okay.
Today, okay? Adjourn to June 30th at what time, Jen?
June 30th, Judge. We don't have.
Jeez, what's wrong with me? All right, July 7th.
9:30.
Sorry, Ms. Austin, I'm going to be out of town that day. July 7th at 9:30.
Your Honor, so I understand.
All right, thanks a lot.
Have a great vacation. Well,
Thank you. Do you have another one for me or not?
that's it for me this morning. Have a great day.
You too. Thanks a lot.
Miss Graham is here now.
Ms. Graham?
That was Mr. Lechner's.
Oh, good. Okay. Owners Management versus Kyra Graham, 2501942. Good morning, Ms. Graham. Your name?
Good morning, Kara Graham, and I apologize. My Wi-Fi had disconnected. I had to get my daughter up to use her hotspot.
No worries. Mr. Lechner?
Good morning again, Your Honor. Attorney David Lechner on behalf of Owners Management.
All right. What do we have here?
We were here on May 29th. Ms. Graham said she was going to apply for rental assistance. She did apply for rental assistance and did provide proof to the court. I spoke with Ms. Graham about it. She doesn't have an answer from them yet. She will find out, I believe, by this Friday. In the interim, I spoke to her about a conditional dismissal, and she's agreed to that. So we would like to enter a conditional dismissal with rent to owe right now is $2,096.71. Costs are $242.69. That's a filing fee of $127.80 along with the second mailing. And then service fee is $41 and statutory legal fee is $75. And then there's late fees of $101. Those are less than $70 a month because they're from April to present. For a total $2,440.40.
All right. So what's the terms of the conditional dismissal?
She's to pay that amount on or before June 27th. And the case will stay dismissed or move out before that date, one or the other.
Do you understand Okay, go ahead.
And I did explain MCR 4201J to Ms. Graham as well.
Do you understand everything he just said, Ms. Graham?
Yes, I do.
Do you agree that you owe that amount of $2440.46, I believe?
Yes, sir.
And you understand that he tells me that you agree to a conditional dismissal whereby the case will be dismissed now, but you have to pay that amount or vacate on or before June 27th. If you fail to do that, then this case will, he'll convert this to a judgment and an application for a writ will be filed and you'll be evicted. Do you understand that?
Yes, I do.
Now, since you're unrepresented by a lawyer, you have 3 business days to come in here and fill out a motion to set aside that adjudication, that dismissal, and you have 10 days to appeal. Do you understand that?
Yes, Your Honor.
Does he have your permission to sign your name to that proposed conditional dismissal?
Yes, Your Honor.
You understand everything?
Yes, I do.
Any questions?
No, not at this point.
I wish you well.
Your Honor,
Thank you so much.
just one point of clarification. I also explained to Ms. Graham that I would be checking box 4B, paragraph 4B, which means that if she does not comply, that upon application, the order would be entered without a further hearing.
And you understand that, right, ma'am?
Yes, I do.
All right. I wish you well. Good luck to you. Thank you very much.
Thank you so much. You have a wonderful day.
You too. South Point. Is that it for you?
That is, Your Honor. Thank you very much.
Have a good day. Thanks.
You
South
as well.
Point versus Matthew Wentz, 2501970. Good
morning again, Your Honor. Max Gilboa on behalf of plaintiff.
Is he here?
Defendant did not show up on Zoom, Your Honor.
Counsel, you can take a default.
You got it, Your Honor. At this time, plaintiff moves for the entry of a default judgment. We've got a rent to retain on this one in the amount of $486.21. Court cost about $179, giving us our grand total of $665.21 with a writ date of June 26, 2025. This is a non-payment case for possession only.
Then failed to appear. The relief requested will be granted. This is a second hearing. Default judgment's entered. Writ date will be on the 26th of June of 25, and the amount to be paid to save is $665.21. Do you have another one, Mr. Mudar?
I believe that's it from me, Your Honor.
Have a great day. Good luck. I wish you a speedy recovery there. Thank you.
Thank you, Your Honor. You and your court staff have a wonderful rest of your day.
Thanks a lot. Okay. Do we have Zachary? Do we have Woodhaven out there?
He's out
there. People against Zachary Tyar, T-I-A-R, Bogas, 25W713437. Good morning, Detective. Your name?
Morning, Your Honor. Detective Sterno with the Woodhaven Police Department.
Raise your right hand, please. Do you solemnly swear or affirm under penalties of perjury that the testimony you will give in these proceedings Will be the whole truth, so help you God.
I do.
Okay, go ahead.
On March 10th, 2025, Officers Zimmers, Meadows, Guzman were dispatched to 25227 Oxford for a follow-up to make an arrest on a Zachary Bogatz regarding a domestic violence incident he was involved with his wife, Brittany Childers. Officers arrived at the address and they were able to locate Zachary Bogatz and take him into custody. Zachary was transported back to the Woodhaven Police Department where he was photographed and fingerprinted. During the processing, Officer Zimmers was checking Zachary's clothing and located a clear container with a green lid containing two separate clear bags containing a clearish unknown substance. Officer Zimmers asked Zachary what the substance was, and he stated it was meth. Also in the container were more clear baggies that were unused. Officer Zimmers continued checking Zachary's belongings and located a small clear Ziploc bag folded in his wallet containing a whitish clear powder. Zachary was asked what the substance was, and he stated, "Meth like my personal," was his statement.
Meth like my what?
Like my personal is what the report states that Zachary stated.
Okay.
The clear container, folded baggie, and Zachary stated where meth were placed into evidence bags and sealed and placed in the evidence locker. Excuse me, sorry. And now that signed the case for review, Zachary was ultimately charged for domestic violence, but the evidence that was located by Officer Zimmers during processing, I took to the Michigan State Police lab for processing, and the results returned for the evidence came back positive for methamphetamine for approximately 0.4843 grams and positive for cocaine for approximately 0.8056 grams. So I submitted a separate warrant for possession, and ultimately that concludes my reading.
Okay, I want you to take your time. Do you have evidence of these prior convictions set forth on the habitual third notice? There should be an attempt possession of meth conviction June of the 30th of 23 in the Lane County Circuit Court. Let's start with that one.
Right here, let me pull up the CCH real quick and verify that.
Take your time. And then I have another one from May 3 of 24 for possession of meth in the Circuit Court, Lane. So June 30, 23, there should be an attempt possession of meth. And then May 3, 24, possession of meth, both in the Wayne County Circuit Court. Let me save you some time. I'm looking at the CCH. We got a June 30, 23, attempt possession of meth. May 3, 24. Looks like he was charged with delivery or manufacture. Either way, there was a conviction. Oh, wait, there's others here. So yeah, he's I'm going to authorize, there's sufficient evidence on this record. The one is actually for, it looks like delivery or manufacture of meth on May 3, 24. Yeah, I'm gonna change that on here. I mean, it is the same statute. I'll just add the word delivery after possession of. I'm gonna go ahead and initial those and authorize the issuance of the complaint and warrant. You signed it, I'm signing it, I'm signing the complaint. You are all set. Have a good day. Thank you.
Thank you, Your Honor. I appreciate it. Thank you.
All right. Donald versus Ronald Pitaway. 2502023. Who's Donald? Who's Ronald? Come on up here.
They're both down.
Your name, sir?
He's Donald Pitaway Senior, I'm Donald Pitaway Junior.
Well, who's the plaintiff? I can't even tell.
Me, but my father was the homeowner and stuff, and we had a discussion about that last time we were here in court.
Wait a minute. Who filed the claim?
I did.
You can't do that. Didn't I tell you that? Did I not tell you that?
Tell me.
Did I not tell you that?
Yeah, you said something about, well, you're not the homeowner.
Well, and so I adjourned it. You got to get a lawyer to handle this for you, sir.
I did.
It's not for you, it's for him.
I did wind up contacting an attorney. I don't have I can't meet with him until June 30th.
Your name?
Ronald Pitaway.
Who owns this home? You own this home? Yes? I can't hear you.
Yes.
And you're Donald Pitaway Senior, right?
Yes.
And where's the property? On Maple Lane?
No, 2067 on Churchill Avenue.
Why is-
The Maple Lane is where he lives.
That's not where I live. My address is.
The property that we're talking about here, is it for Churchill Avenue? Is it for?
Yes. Yes.
That's where we live, Churchill.
Do you live there?
That's my residence, yes. It's on my driver's license. I live there, my property's there. He tried to take it.
Hang on a second.
They locked the doors on me and changed.
Time out. Time out. You're his son? Are you his son?
Yes.
Oh, this isn't very fun.
Exactly.
Who else lives at that Churchill address? Do you live there, Don Pitaway Senior?
Yes, I do.
Do you live there, Don Pitaway Junior?
Correct.
And so does Ronald?
And he moved his stuff to the Maple Lane address, and he's trying to get away with living at two addresses when I'm trying to evict him. What's basically gonna happen?
Hang on. You are not trying to do anything because you're not the plaintiff. What do you mean, whatever? Mr.
My father's 85 years old, sir.
I get it. I don't think he's being disrespectful, but I can't just say whatever. I have to have the real party and interest starting the action. That being said, Ronald, come on. What was yesterday again?
June 15th,
Yeah, I know. What else was it?
Father's Day, I was there.
I know.
He
Stop. I didn't ask you that. It was Father's Day, right?
Yeah, I just stopped and started to fight yesterday.
Stop.
All my brothers were there.
Listen to me. How many dads you got? That's what I want you to answer. How many fathers you got?
One.
Okay. Yesterday was Father's Day. What a sad commentary that an 85-year-old, and how old are you?
He's 84. I'm just being accurate, sir.
All right. How old are you?
853.
My dad. See that guy in the wall?
I know Gerald.
Huh?
Gerald McDonald.
Who's my dad?
Yeah.
53 when he died. How old are you?
56.
You guys are carrying on like that in this world that's so short, this silly, ridiculous, and I've got a lot of other words I could call it, but they wouldn't be appropriate. Now, why aren't you just vacating the house without putting people through all this nonsense? I I did not finish asking my question. You keep interrupting me. Why aren't you just moving out of the house? You live on Maple Lane? Yes or no? Do you live on Maple Lane, yes or no?
My address of residence is 20679 Churchill Avenue on my driver's license. Certain my property's there, and I have money invested in that house, and they're trying to take it. He is my brother. I got about $30,000. Who else will do that for their father, sir?
Oh.
Not this deadbeat who's got my dad broke.
Hang on. Watch your mouths. Now listen, 85-48, don't start swearing in here. I'm as serious as a heart attack now. Stop it.
Yes, sir.
Do you have a lease with him?
A red lease, sir.
I'm talking to your dad. What did I tell you last week? I said you can't be his representative here. You're not a, listen, sir, listen to me, please. Just so you don't think I'm being mean or anything. I cannot allow people to engage in the unauthorized practice of law, and that's what you're doing right now. You're not a lawyer, and you can't represent him. Period. I can't go over and set up a medical office and act like a doctor. You're not going to act like a lawyer. Now, I thought I made that clear. Did I not make that clear?
Yes, you made that clear.
Then why are you here doing the same thing? I don't care what the reason. Look, let me just try to help you guys. Maybe you can save a lot of people a lot of time and a lot of money on lawyers that maybe isn't quite necessary. What do you mean you put $30,000 into the house?
I got the receipts. I put a whole back patio.
I want to, you put in a back patio?
All brick pavers, 2 fireplaces, a hot tub. I did it for my mother because.
How long ago?
It's like right around the start on COVID, it got delayed.
Is your mother still alive?
No, she passed away.
When?
18.
So you're telling me you put in brick pavers and what else?
2 fireplaces, a hot tub. Well,
Where's this all at?
It's all on at my dad's.
In the back?
Yes, sir. I got pictures and
And you did this 7-8 years ago?
No, it's a few years ago. I promised my mom I'd take care of it.
Wait a minute. When did you do that? What year?
It started in 2020.
But your mom was already deceased.
I promised her I'd take care of it.
Your mom was already
I
deceased.
promised her I'd take care of it. I made a promise to my mom and I honored my aunt. When I moved in there for my divorce, I promised her I'd take care of it. A tree fell down, destroyed the pool. They paid to have that. My dad didn't have the money. I did. So I pulled it out and I took care of it. Like I promised.
You did this 5 years ago.
It started off.
Was there any agreement that he was? You told your mom you were going to do this, right?
Yes, I did.
Because you wanted to be a good son to your mother.
Yes, sir.
And you took care of it even after your mother died.
Yes, sir.
Do you have anything in writing that says your mother, stop, don't interrupt me. Do you have anything in writing that says your father, Don Pittaway Sr. here, agreed to pay you? Yes or no?
No.
You have anything in writing from your mother saying she agreed to pay you, even though this happened 2 years after she passed?
Anything I did.
Yes or no?
No.
How are you going to win this? You want to say something? How long you been living there?
Since like 2018.
18? How much you been paying in rent?
$50 a week, just like he paid. My other brother pays 0. And everything I put into the house, my dad said would be taken off my rent.
Have you been paying the rent at $50 a month or a week?
My dad took like $500.
Sure.
Yes.
Have you been paying your father $50 a week?
Yeah, he just took like $500 on my bank account.
No.
They take more than.
Wait. You have this terrible habit of interrupting me. Have you been paying since 2018 $50 per week?
Yes,
How you been paying that?
cash,
Check?
cash.
Did he take 50? Is he been paying you 50 a week? Look. You know what I think?
I have proof.
How do you have proof? Did he sign receipts? How do you have proof? Did he sign receipts saying every week, my son, Ronald Pittaway, paid me $50 to cover his rent for this past week? Do you have proof of that? You have receipts like that? I'm asking you a question.
But make sure I don't interrupt you, sir. I got my bank statements right there. My dad took it out of my bank account. From the bank, I got them out there. They'll verify that he took it out.
For 6 years, hang on.
He's on my bank account.
For 6 years, he's been taking $50 a
He
week.
takes money whenever he wants to.
Have you been taking money out of his account?
Here's what happened. I didn't even know that he was on the account. And then all of a sudden, I found out he hasn't been paying me any rent. He pays the rent. He's paying.
Who's he?
Ronnie doesn't pay nothing.
Who's he? Don Pittaway Jr.? You pointed to this son. Wait, you pointed to this son, right?
Right.
He's been paying rent.
He's been paying, but the other guy right over there has not. And every time I try to collect from him or something, no, I ain't giving nothing. Oh God, it was been like 6 months ago or something. I found out that he has a bank account where I'm at, and my name's on there as runner-up or whatever you want to call it. So I start taking money out of there.
You did?
Just a minute. He found out about it, and so he cut me off of there. I can't go in there and get money out of the bank anymore for my $50 because he's killed me on.
You kind of lost me. Who's on the bank account?
He's the head on the bank account, and I just found out by accident that I was on there. So I said, well, good, then I'm going to start taking my $50 a week.
When did you start doing that?
Oh, what, about a year ago or something like that? Whatever it was, I would just take it, $50, and he found out, and then he just cut me off of there. But for years, he didn't pay me nothing. My son here did.
Even if you've been paying, you have nothing here. You have nothing. He has a right to kick you out. You guys didn't sign a 10-year agreement or anything, did you? He has a right to kick you out.
Everything is verbal.
All right, well, that isn't good enough.
I understand that part. But he still can't change the locks and throw me out without evicting me.
You didn't do that, did you?
Yeah, he did.
Who's he?
My brother. I
We
told him
also
that.
got
You guys are trying to-
criminal complaints against.
You guys are trying-
malicious destruction of property. I'd like to let you see if you know what you see.
You guys are trying to be your own lawyer. That never ends well. Never. Oh, how do families get this angry at one another? I don't get it. You have to heed my advice. You cannot represent your father. He seems completely competent to me, by the way. Why don't you have a seat, Mr. Don Pittaway Jr. in the back? And Don Pittaway Sr., would you like to stand at the podium or would you like to have a seat at the council table right there?
I don't know.
No, I'm just asking you how you're going to feel more comfortable. You want to stand or you want to sit?
I'll probably sit, I guess.
Sit. Why don't you sit down? You're not getting anywhere with me, Ronald Pittaway. $50 a week on Churchill and Brownstown, that's a pretty nice area. Will you move me in for $50 a week? I'm just kidding.
No.
I don't want to hear anymore. This is silly. Do you also live on Maple Lane?
Yes, I also live on Maple Lane.
Why
I
do
had to
you,
move in there because they changed lots on me. Well, some of my buddies, when his dad died, emptied out his house. They lived on Sutton Farms. So I was helping him, his dad had a hoarder.
you have, I'll tell you what I'm gonna do.
They've got my washer, dryer, my hot tub.
I don't even think I have a triable issue now. I really don't. I have to have a triable issue. I'm telling you right now, Don Pittaway Jr., don't stand up at that podium again and act like you're representing your father. Do you hear me?
I understand.
This is kind of all coming back to me now. I'm adjourning this 1 week. You guys want to come in and tell me the same kind of thing? I'm going to order you out in 10 days. You want to come in here if you've got a lawyer or some legal argument to make that's legitimate, then I'm going to find there's a triable issue. So far, I haven't. I find this more sad than anything. I really do. I get this families fight, dads and sons and mothers and daughters and mothers and sons and dads and daughters, but I don't understand it. I'm adjourning this case 1 week. If you don't come back with some legitimate legal argument other than I honored my mother's wishes that she asked me before she died, and in 2020 did some work around the house. Stop. You look like you were gonna cut me off again. Then I'm gonna order you out. You wanna try some other legal theories? Feel free. I'm giving you 1 week to get a lawyer, to do whatever you wanna do. Maybe you need to find another one, Don Pittaway Senior. I don't care. June 23rd at what time, Jen?
10:30, Your Honor.
At 10:30 in the morning, and that's it. I find this incredibly sad. Good luck.
Can I get my property out of there?
I don't know what your decision is.
Well.
Are you saying you want to relinquish?
Like I said, that I'm gonna have 10 days and I want to be able to go get my stuff. I got the doors locked. I have to call the police to get it.
Sit down. You're pushing me. Don't push me. Now you want to stand from the pews back there and start debating why he shouldn't be able to do that? You're not the real party of interest. You got no business being here except to observe. How many times I got to tell you that? Wait. When I issue this order, this judgment, if I decide to enter the judgment, I'm still going to give you a week if you want. You guys, sir, you're going to let him come in and get his property. If I have to treat you all like children and have the police stand by and set a specific time, then I will do that. Stop. Stop acting like children.
He was there the other day and taking his stuff out.
Is that true?
Still some left
Some of the
in
stuff
there.
but my washer and dryer, my dad tried to.
Is that true?
Yes, but they wouldn't let me,
hang on.
they wouldn't let me in the house get the other stuff.
Yeah.
No.
Hang
They wouldn't
on.
let me in the house. Mark locked the door.
Stop.
He doesn't own
Stop.
a washer or dryer.
I got proof.
I'm getting tired of hearing you say you have proof. Where's your proof?
I bought the washer and dryer from Sears. It was on my credit card. Please.
How many years ago?
Shoot, about 20.
You're not taking the washer and dryer, okay? You're not taking the washer and dryer that you bought 20 years ago. What else?
My hot tub out the back.
Do we have a problem with him taking the hot tub? Not you. You don't say a word, Mr. Pittaway Jr. You have a problem with him taking his hot tub?
Nope.
What else do you want besides your hot tub?
Like I said, the freezer and the two pitchers that are downstairs that Sean had stored that they wouldn't let me get access to.
What's the you have a problem with him taking the freezer?
No, it's empty.
You have a problem with
Sit
him?
down there.
What's the pinchers? I don't know what you mean.
Pictures. My friend stored some of his stuff there.
Pictures.
He's got some antique.
What kind of pictures?
They're antique pictures. They were sitting on top of the freezer.
Well, you gotta be more descriptive.
They're my friend Sean's. When we were moving his dad out.
You gotta be more descriptive.
Two big pictures, antique pictures. He's
Of
got,
what?
they're just antique pictures he had down there. He was
I know,
storing-
but are they to depict the baseball field, World War II? What do they depict?
I couldn't tell you.
Well, then why do you need them
Because
so
they're my
bad?
friends, I need to get them out of there. And his motorcycle's in my dad's garage. They were storing it for my dad. My brother got mad, pulled the gun out, poked me with it.
Oh my
On
God, you
January
guys are out of
27th.
control.
Listen, and
Hang on,
I'm
hang on. Do you have is there a motorcycle in the garage?
They come over to get it, just the other day, and, they couldn't get it started, so he towed it back into the garage. They're gonna come.
Is that
get it.
true?
Yes.
Okay, so it doesn't sound like anybody disagrees about the freezer. Hang on, hang on, or the motorcycle, or the pictures. I guess, do you disagree that he can take the pictures?
They're his, take them. We told him he can have that freezer, and, what else is that, Donnie?
What else do you need?
That's just everything I have. I don't know where they put everything.
Hang on.
They took my room, put stuff in the. they put
Mr.
stuff in the
Pitaway,
box.
Mr. Pitaway, I want a list from you. So far, you've told me two antique pictures that you don't have a clue of what they depict. Which I guess if I wanted a picture, I'd at least know.
Can I suggest something to be just real quick about this, to save the board's time? Can I have 30 days, I'll have it out, I'll go there with my dad, we'll go through this stuff, I'll get it out in 30 days. And if you don't hear from us, you know everything's good, but give us 30 days, I'll have it out. And then.
Hang on.
Is that fair?
I can adjourn this a week.
30 days.
Why do you need 30 days? Where are you working at?
General Motors, we're there every day of the week.
You've got 1 week. Come on.
We have a trailer, I'm trying to figure, I gotta find storage and everything else, I mean.
I think Don Jr. Pitaway should stay out of this, to tell you the truth. Don Senior, can you collaborate okay with your son here? I'm talking about with Ronald.
I'd rather handle it between my dad guys.
What's that?
I'd rather handle it between my dad guys. And I'll talk to him on the phone, tell him we're coming over. And if, like I said, it's gonna take about 30 days.
Okay, hang on. What do you want to do, Mr. Pitaway Senior?
I don't know why it's gonna take 30 days.
I don't either.
How do you pick up a hot tub?
You get a truck and you get some friends and they come and help you. You should be able to do that today if you want.
That's not how a hot tub works.
Okay. Well, how do you intend to move the hot tub?
Well, I'm gonna get some money, I'm gonna call people that deliver and see if they'll come back and get it. The guy that dropped it off, I'm trying to get a hold of him and see if he'll do it. Get some people, where it's at, you kind of gotta wheel it.
He filed this May 20th. How about I'm gonna adjourn it 1 week. I'm gonna let you guys figure this out.
Can I get 2?
I'm not gonna be here in 2 and I don't wanna move at 3. Do you have a problem with 3 weeks? If I adjourn this 3 weeks?
I'd rather do it sooner than that, but whatever.
I'm not gonna be here June 30th, so it's either gotta be June 23 or July 7th. Is that okay? July 7th?
I guess.
At what time, Jen?
10 o'clock.
At 10 a.m. All right, that's what I'm doing. Okay? July the 7th at 10 a.m. You guys come back. Don Pitaway Jr., I think you should probably really stay out of this, and I don't think I can emphasize that enough, and I know you're not gonna listen.
We have a younger son, and Donnie's been taking care of him or whatever. That's why he's basically running everything, that's,
All right.
I'm gonna be 85, and I ain't got that long to go.
And I mean, and that's what exactly my point is. It's a sad commentary. You guys are fighting like this. Jeez. Look, I'm gonna move this.
I don't hate my son. He just acted up a few times, that's all.
Okay. I would hope that you guys could resolve this. Really. I don't want
Well,
to
we did the other day, but let's just see what's happening, so whatever.
be
Gonna
nice.
get all this stuff out of the garage.
If this is you and your brother fighting, let this be you and your brother not seeing each other, but stay in touch with your dad. July 7th, come on back here. You guys see what you can work out in the meantime, will you?
Thank you, Ron.
I really mean that. Good luck. Don Jr., maybe you should stay out of this.
No.
But don't come up to the podium again, sir. Did you hear what I said? Yes?
Yes.
Okay. See you in 3 weeks. Good luck. Barnaby Bell versus Tamisha Bell. This is 25-02024. Mr. Asphalt, which one do you have? Do I have other files?
There's 2 for 10:30, Your Honor.
All right.
Judge, could you pass this case? I'm going to be through in another courtroom here in 5 minutes.
Yeah, I'll pass the other one. Which
Thank
one
you.
is that? Which
He's
case?
got the Truman Estates.
Yeah, no problem. Your name, ma'am?
That is Tamisha Moore.
Okay, so you're the defendant. Where's Bobby Bell at?
I've not had him check in this morning.
Do you know why he's not here by chance?
Because all of this was hogwash.
He claims you owe him $35,028.90.
I do not.
Remorses, just having those comments in front of his children. I think he takes pride in acting appropriately. The character letter that I provided is from the ex-husband of his current wife, who is in the courtroom with us, and he has nothing but good things to say about how Mr. Metzger treats his children and how he behaves. I believe my client now has the children that he has. They're in your care for the summer. So I know my client just only wants to have a promising future with his children. He wants to co-parent appropriately. He wants, I guess family law court might have to deal with some of those other issues, but I suppose at some point it'd be nice if the parents in this case could communicate better. And I know that's what my client would like as well.
Joining us here is the complaining witness, Zachary. Nick Wilson, Nicholas Wilson, and Lindsay Metzger. Here's the original affidavit. It's 1 paragraph long. That's what I use for the factual basis. On May 22nd, officers from Sturgis Department of Public Safety responded to an assault complaint that occurred at Wall School, 702 West Lafayette. Upon arrival, officers made contact with the victims Lindsay Metzger and her husband Nicholas Wilson. Victim Wilson advised that he was involved in a verbal altercation with Lindsay's ex-husband Zachary Ross Metzger. When Zachary headbutted Nicholas in the face, the impact from the headbutt caused Nicholas's glasses to come down on the bridge of his nose, cause a minor laceration. Zachary then shoved his ex-wife Lindsay, and she attempted to separate Nicholas and Zachary. Nicholas sustained a minor laceration, and Lindsay had no injuries to report. That was certainly a sufficient factual basis for disturbing the peace. Mr. Wilson or Ms. Metzger, is there anything you wish to say to me?
Yes.
Okay. Go ahead.
I want to be very clear that I'm not here out of bitterness. I am here because I'm afraid, because I believe repeated violent behavior without real consequences only leads to more of the same. This wasn't a one-time outburst. This was a pattern that's gone on for over a decade. One that's escalated, not improved, despite previous court orders, therapy, and opportunities for change. And this incident happened in front of our son. For that reason, I'm respectfully asking the court to consider sentencing Zach to a minimum of 30 days in jail without allowed under this charge, followed by probation with mandatory anger management and behavior therapy. I realize that 30 days isn't going to undo the past, but some time served might finally send a message that his behavior and has consequences, not just for him, but for the child who keeps seeing it and for the people who keep suffering because of it. I'm asking not just for justice, but for protection, for peace, for safety, to be taken seriously.
Thank you. Mr. Wilson, you wish to say anything?
Just quickly, you know, with the communication part, this whole thing started because she was trying to communicate with him about their son. I made a comment because I was annoyed with him ignoring the fact that she was talking to him about his son, and then followed and just
Berated.
followed with voices back and forth, mine and his both, until it got all the way to the parking lot and I couldn't handle it. You know, it's not the first time he's outburst towards me. He usually is over the phone, but it's fine. I want him to learn that there's consequences to his actions. That's literally it. That's the only reason why I'm even doing this right now. Thank you.
Ms. Davis, we did take a plea to disturbing the peace. Do you have anything further you wish to say about it?
I just wanted to point out to the court that this isn't the first assaultive crime that Mr. Metzger has pled to or been convicted of. It appears there's still warrants in Indiana, but it would be for a probation violation or an assaultive crime using bodily waste that was pled down to like a disturbing the peace there, but he was placed on a probation. He also appears to have done the anger management course previously on his first domestic violence charge. And these were all within just the past couple of years. There was also an incident a few years before that in 2017 where there was an assault at the Doyle Center that no charges ended up being filed, but certainly leads me to believe that he's got some anger management issues. The court, obviously, with a disturbing the peace plea, there's not much that you can do, but we would ask that you take the victim's request into consideration with this. Thank you.
All right. Mr. Metzger, you did plead no contest, and the factual basis I got from the affidavit of probable cause, and it's consistent with what the complainants say. This was a child's event. There was words being exchanged. Anyway, it was an unpleasant thing for everyone involved. And I got these letters from your current wife's ex and your mother-in-law, your current wife's mother, I guess, giving their opinion. For everybody involved, there is a statute that came into effect several years ago with the criminal justice reform package that presumes there is no jail, especially in minor cases like this. And it also presumes that there is no probation. So the district judges, and I teach sentencing, are supposed to start with the presumption that there isn't any jail, particularly for minor offenses like 90-day offenses like this. This is not an assaultive offense, it's a disturbance offense. There doesn't appear to be any restitution issue. Where are you wanted in the state of Indiana?
Elkhart, Indiana.
What are you doing about that?
I've called a couple bail bondsmen because I guess in Indiana you have to go through a bail bondsman to turn yourself in. I was pulled over and caught in Indiana with a couple of grams of weed in my trunk. At the time I had worked at a dispensary and I was going to meet my wife, or my now wife, my girlfriend at the time, at her house, and they pulled me over for a license plate light and got me for a marijuana charge. And they put me on non-reporting probation since I lived in Michigan. The non-reporting probation, they decided to report me at the end, and I still failed for THC in my system, so they put me on a probation violation. And I'm currently just trying to pay my fines down on that before I turn myself in, so that way it looks better to the courts. I can't really afford to
Where do
miss
you
work
work?
right now. At Burwood LTD.
Oh, yeah.
And I was working side work for Ron McAllister for quite some time, but after he passed, that sort of went out the door, obviously. It's just I have so much in bills right now for just keeping a roof over our heads. It's a lot.
All right, well, when you're gonna turn yourself in on that case is never. You're gonna stay out of Indiana, and it's never a good time to deal with it. Doesn't sound like a terribly serious matter.
And this offense that was said that I had been charged with some assault, that I got a letter in the mail saying all of those charges were dismissed. So the only thing that I'm out on right now is the marijuana charge.
And where was the assault?
It was in Bristol, Michigan, or Indiana, Bristol, Indiana, I'm sorry.
You had a 2010 assault and battery that was reduced to disturbing the peace, and that's been set aside due to the passage of time.
Yeah, that was.
Then you had the domestic violence class that Judge Pattison had, and you did apparently complete that probation.
Yes, I did, sir.
So that was made non-public.
Yeah, the one that I was referencing was in the state of Indiana on Indiana My Case with his name and date of birth, Elkhart Superior Court. He was originally charged with battery resulting in bodily injury, battery by bodily waste, and he ended up pleading to disorderly conduct.
And I got a letter in the mail saying that was dismissed. I still have to pay my fines on it. Is the reason why
There
it's
was
still
a
there.
probation violation.
Probation was for the marijuana charge.
All right, well, I'm always sort of handcuffed when I've got it. Rarely do I do jail and disturbing the peace. I don't say never, but I'm gonna do a zero fine, $75 crime victims' rights fee, a $50 state minimum fee, $150 attorney fee. That's $275. I'll give you some time to pay that. I'm gonna make that due by September 30th. I'm gonna order 2 days jail, credit 1. You're gonna go to our jail and they'll call Elkhart and say that they've got a warrant for you. So this will be your opportunity to take care of your Elkhart case and post a bond as opposed to ducking it. So if Elkhart doesn't want you, they'll let you out. If they do, they'll take you to Elkhart and you can go deal with that. Let me give you this. I'm going to give you several months to pay this. For everybody's sake, you need to take care of that.
Sir, if I could say something real quick, sir, before you make that final judgment.
Yes.
I do have my son for the summer.
So we wait till fall till you get arrested?
Well, no, I just have.
You need to go to Elkhart and take care of it. It's as simple as
understand
that. And this way you can go to Elkhart, post a bond and come spend time with your son. All right, you're good to go, sir.
Stand, put your hands behind your back.
If they don't want you, you'll be released tomorrow. If they do, you'll go to Elkhart and deal with that.
Do you have anything else that needs to go to your wife?
All right, thank you.
Thank you.
All right, we have another 1030 matter with Miss Ives, which is not Susanna Lee Hoffs, but Samantha Jo Hoff. This started as a felony, possession of methamphetamine. It was reduced to use of methamphetamine. Sorry. not completely clear to me. This was a search warrant at a house. Ms. Hoff was there. They found some stuff outside in her car. Basically, she had a meth pipe. She's been on pretrial services, and I inquired of pretrial services this morning how Ms. Hoff was doing. And here's what Mandy Grubb says. She is doing well. She checks in weekly and has been in compliance with community corrections directives. Thank you. So she's been in compliance with that. Does have some history, but basically this is a possession of a pipe with some residue in it. She did spend 2 days in jail, I believe. Ms. Ives, what would you like me to know?
Well, we do have some updated medical records or therapy records from the Bowen Center with me today. If I could, I'll show them to the prosecutor first. This is just to show that she's been enrolled in the group called Matrix Recovery. That meets on Thursdays, and these are the pages that confirm her. Ron, if I may approach with those.
Yes, I adjourned her for 2 things, to see how she was doing at the Bowen Center and to pay off a ticket. And I think she paid off the ticket. Did you?
I went upstairs and I made a $40 payment. But I got a job at the BP, but when I got my stuff back from the police department, I did not get my ID back. So I just got my ID yesterday. For my college stuff, I've been helping a recently new business, like get to land jobs, like roofing jobs to, so they could build their business and do everything, because I finished my associates, online college stuff for business degree. So I did make a payment but they just gave me a new court date, and I told her that I was going to look to see what I was able to make a payment, because I was going to make at least a $20 payment if it was possible. But I also got my 2 older boys that I have now. My 2 younger ones are still in the care of LaGrange, but hopefully that'll change in August when we go to court. But I have my 2 older boys now.
All right. That must have taken care of it here. Let's see here. So this was June 13th, but you'd been involved back in May when I talked to you. Here's some stuff.
Yeah.
May 21st, May 29th. All right, very good. All right. Where are you living?
I'm living at my grandmother's because my kids are in care with my mother. But the goal is to be able to go back to my mom's with my kids, because until I get a better job, I can't really afford to live on my own.
Where is your mom?
It's in Howe. Right now I currently live in LaGrange.
And your grandmother is in LaGrange?
Yes.
All right, now that was that financial transaction device probation you're on to judge, the probation's over, but you're still paying on your
Yes.
fines and costs. Okay, looks like they've recalled that warrant. All right, Ms. Davis, anything further on this one?
No, Your Honor, obviously I can't authenticate the stuff that she brought in from the Bowen Center, but if she's doing that, that's certainly a positive. It's a dirty pipe that was in her sweatshirt, a place where she shouldn't have been hanging out. So hopefully she's on the right track now. And that leaves the court's discretion. Thank you.
Wrong place, wrong time, wrong people. But methamphetamine is powerfully addictive. You're living in Indiana. You're doing what I would order you to do if you were on probation. You've complied with pretrial services. You've made payments on your other stuff, and you've stayed in with treatment. Just going to close this out. 2 days jail credit, 2 days. Again, I'm going to make your fine 0 because you don't have very much money, but there's a $75 crime victims' rights fee, a $50 state minimum fee, and a $150 attorney fee, which is $275. I'm gonna put you on a payment plan. I'd like you to pay at least $25 per month. And Mandy said you checked in, you did good. If I gave you a test today, what would it show?
I'd be clean. I test for DHS down in LaGrange, and like I said, I have my 2 older boys, now. So I was really stressing them out if I was gonna get locked up, because it's not like, I don't know, I know that normally for a meth charge, you get locked up. So I was like prepared today, brought my mom with me so I could sign my 2 older boys to her if I did go to jail, because
Well, you're gonna sink or swim down in Indiana. You
Very
got
true.
PS, they are testing you. I don't know when the last one was. When you say probably clean, means there's something in there. Probably marijuana, maybe, I don't know, but,
I think I heard her say that she would definitely be clean.
Yeah, I said I would be clean.
oh, I thought she said probably clean.
No, I did not hear that. I think
Oh.
I need to play it back, but I just want to make sure that.
Well, she is testing in Indiana. We aren't testing her, but she's been in compliance, so you're on the right path, as Ms. Davis says, and let's hope that can stay. I want you to go out to the counter and set up that payment plan and make sure they've got your updated information. I'm going to give you, I'll keep this work thing. I'm gonna give you these Bowen Center stuff
Okay.
back. I don't want them. All right, see, hello, Mr. Bush. We're a little early on page Savage, but if I can get the probation department up here, we can get right to it. It's a drinking, driving, using weapon.
The grand jury on October 11th, 2023. It's more or less over a year and a half ago, charging you with the 2nd degree felony of as 2 or more. Does the defendant waive I'm sorry, earlier in this case, you were charged by an indictment handed up by the grand jury on October 11th, 2023. It's more or less over a year and a half ago, charging you with the 2nd degree felony of aggravated assault with a deadly weapon. And then you entered a plea of guilty March 17th of this year. And the agreement stated that whatever sentence shall not exceed a cap of 10 years in prison. A pre-sentence report has been prepared in this case. Have the parties had an opportunity to review it?
Yes, Judge.
And are there any corrections or changes to it?
Not to my knowledge, Judge.
Yes, and there are no changes, Judge.
All right, then it will be made a part of the record for all purposes without changes. The agreement, what was the date that this was? Let me check, please.
I believe you said it.
March 17th.
It might be in
I
mine.
don't think so.
Hold on, it might be in my retrieve. Let me look.
It's not, yeah, March 17th is not a date that I'm showing.
It's in my retrieve.
I don't know what that means.
It-
Retrieve,
Yeah,
that's to get something back.
It's also
You're
pretty
going,
dog,
you know,
actually.
like a retriever,
Yes,
a golden retriever. Chesapeake Bay.
Well, I have them in my retrieve where
it's a good dog, Judge.
They're good dogs, smart dogs.
it'll actually be under February 24th.
So then, what we were looking at was like two options.
Yes, sir.
Second degree felony, aggravated assault, no less than 2, nor more than 10 years confinement in prison. It would have been up to 20, is 2 to 20 is the punishment range for a second degree felon, but your attorney was able to limit the exposure to a maximum of 10 years, but it's 2 to 10 years in prison. Also, you could be placed on deferred or unadjudicated probation, actually, which could be up to 10 years in length, where you would not be found guilty. It would be a form of probation. Regular probation is a third option under law, but it is not, you're not eligible for it whenever a deadly weapon is used in the commission of an offense. Then a court cannot, the judge cannot grant regular probation. So a pre-sentence report has been prepared. There are no objections to it.
Correct.
And it is made a part of the record for all purposes. All right, Ms. Minaldi, on behalf of the defense, you may argue on his behalf.
Yes, Judge. Obviously, we have an option that we are advocating for today. We would request that he be put on deferred or unadjudicated probation for this offense. As you'll note in the pre-sentence report that you have in front of you, and that's been made a part of the record, he has no felony convictions or really any felony issues that he's been charged with as an adult. He has a support system on his behalf, and I do have 2 letters from his family members if you would like to read over those as well. But he has 2 people in the audience here that are supporting him today. He has the support system at home. He has an uncle who's willing to help him find a job and kind of get away from the lifestyle that he was wrapped up in down here. At least through my conversations that I have had with Tyree in the jail, and since all of this has happened, he has grown very aware of real consequences and real adult consequences, especially since being in the jail. He has expressed a desire to change and rehabilitate and be a law-abiding citizen and a productive member of society. So given that he does have no felony convictions yet, and he has not had a real opportunity at probation, I think that he has spent a lot of time in jail awaiting this point that has given him a different outlook on life. And then from there, he knows what he needs to do to be successful on probation, and he should be given an opportunity to be successful on that probation.
Okay. Okay. Abstain.
Your Honor, this is the 8th individual out of
10 or 11 that are going to be coming before you about this fact pattern. You have previously sentenced the 7 before. Each have made similar arguments like what was done here. Some were actually situated a little bit better than Mr. Simon as far as the fact pattern is concerned. Each of those individuals received pen time. 2 of them were on probation at the time, and after motions to revoke probation, either hearings or not, one was sentenced to 20 years. That was Mr. Michael Williams. Jalen Foxall was sentenced to 15 years. You've sentenced Beatty to 10, the 2 Petrie brothers to 10 years, Charles Johnson to 8 years, and Deion Brooks to 8 years. I read nothing in this report that suggests that Mr. Simon should be treated any differently. The video you've seen on multiple of those sentencings is that if you, I need to know if you recall it. If not, I'd like to play it for you.
No, I remember it, but I want to
The specifics,
look at him.
the specifics about Mr. Simon is the PSI, which is not objected to, tells from the police version that he was striking Mr. Jefferson with a closed fist while carrying a handgun. He is not accepting responsibility fully today. He denies having a weapon. Now, I think that's probably because some of the other defendants that were sentenced were able to get less than 10 years. They got 8 years. And I think factually how that played out is they were not in possession of a weapon. They all collectively acted as a mob in assaulting Mr. Jefferson in one of the more disrespectful acts that we've seen in court as far as the video is concerned. And I know you've got other colorful ways to explain it, but the amount of lawlessness that occurs here at 3:30 in the morning in our county is really, it's disappointing at best.
Normal people are asleep or at work.
So, Judge, I'll need to make arrangements to get that video ready for you. I had hopes that you would recall it, but we can do that, Judge. I just need to make arrangements to do that.
I'll see what this says. I just
Sir,
confirm it with the video. I know what this says in the pre-sentence report, which says he admitted involvement in the altercation, but claims other subjects were the ones in possession of firearms, not him. However, where does it show? I'm going to get this. Mr. Simon, according to probation, wearing a white t-shirt and green shorts, was striking Jefferson with a closed fist while carrying a handgun.
if you'll give me a few moments, Judge, I know I've got some trial copies of, because we have two defendants that are set for trial. I've got some trial copies of those videos upstairs, and I can get it showed to you.
Leave, is there anything you want to say? Mr. Simon, this is your time, your life.
Yes, sir. I just want to say that these 11 months I've been having time to think about it. I just been running through my mind every day what bad decision I made.
What was your bad choices?
First, being there, and then second is striking, just involving myself in the situation.
Were you or were you not carrying a firearm?
No, sir.
Okay, we'll see what the video shows. But this states that you pleaded guilty to striking the victim about the head and the body with your hands and feet. And this states you used or exhibited a deadly weapon, namely a firearm, during the commission of the assault. I'm going to remind you, you pleaded guilty to that under oath. Did you lie to me? You must, because these are the elements of the crime. That's what you pleaded guilty to. And here this states, We went over this. There's your signature right there. This states, I am mentally competent to enter my guilty plea. It's freely and voluntarily made. I have read the charging instrument, the indictment. My attorney has explained it to me. I committed each and every element alleged. I give up my rights to pre-sentence report. I am guilty of the offense and any lesser included offenses. I swear all of this is true. So help me God. Let me repeat once again. You swear all of this is true. So help me God. I've read the indictment. My attorney has explained it to me. I committed each and every element alleged. One of these elements that you admitted is you did then and there use or exhibit a deadly weapon, namely a firearm, during the commission of the offense. Did you just lie to me?
Sir.
That's what you're doing. You said you committed every element. She went over, she's a good lawyer. She goes over these things with you. One of the elements is you used a firearm during the commission of the offense. Not saying that you even struck or stuck it in the face of somebody or shot it. But when you're brandishing a gun and somebody sees it, they're defensive. They're helpless. But this is what it said you did. You used or exhibited a deadly weapon. But you're saying I didn't even have one. Now, to me, which meant you must have lied when you signed this oath, which is perjurious. You commit perjury if you swear to something that's not true. We went over and we go over this real simple. I go over it with you and you sign everything, and we do it as a great precaution so that people don't plead guilty to things that they're confused about or untrue or that are untrue. But we rely on this, the truth, and you swore to it. But now you're saying you didn't have a firearm. Shame on you one way or the other. Shame on you. You're caught in a box now, buddy. I don't like what has just happened. When you plead guilty and you're throwing yourself to the mercy of the court, you fess up to everything that's true. But you don't lie about it in an oath, which you may have done. Because now you're saying, I didn't have a gun, but that's what this sworn. Well, I'm showing what you signed. There it is. That's your signature under oath, buddy. I committed each and every element, and that's one of the elements. You either used or exhibited, showed a firearm, which causes people to be in fear, and then they're submissive. That's what happened. Apparently, in this case, looks like you were part of the beating, and people were beating a poor guy to almost to death. But using firearms, people are submissive, and they can't compete with a firearm. But you're saying you didn't have it, but you admitted it back on the date you signed this, and we went over it. I swear all of this is true, so help me God. What's your final answer? Or do I need to see the video? Did you have a gun with you or not? Okay, let me see the video.
Okay,
and
Judge.
Then we're going to have to, he's admitting he doesn't have a gun or exhibited it, which means we're not taking the deal. He'll go in front of a jury. And let me see that video.
Give me 5 minutes and we'll get a copy upstairs.
You don't have a deal with me, buddy. And juries can't give probation for. Oh, they can give probation for deadly weapon. That they can, but they don't. But I'm not taking a deal when the truth is what's important. You can't play games But I will ask the district attorney to look into perjury, a perjury charge for this. Because you're not going to mislead me by swearing under oath that you committed all the elements of the crime when you didn't. And it's a felony offense to commit perjury. You don't want to carry that around the rest of your life. You're tabbed as a professional liar.
Judge,
But these are all choices that everybody gets to make. And you either make the right choice or the wrong choice. And you live by it, the right choice or the wrong choice.
Judge, if I may, I do believe we're dealing with a law of parties issue here, where all of the defendants were charged with an aggravated assault with a deadly weapon. And if another party had exhibited a deadly weapon, which is my understanding that one of them did, he would also be responsible.
A party
for that.
too.
Yes. So while he may not have had a weapon on himself, he is still able to plead guilty and be guilty of that offense because of the elements of the law.
He would have to have known other people had the weapon and used it and took part in the assault.
Yes, Judge, and I believe that will be exhibited on video.
Somehow assisted them in the commission of the offense. That right? Should have run like the wind away from that. Should have never been, you should have never been a part of this. You should have gotten away from it as fast as possible. What is he's looking for the extent of the injuries of the victim? Does anybody know?
I do not, Judge. This might be a better question for Mr. Mann.
He was listed in critical condition, according to the reports. Does anybody have a difference?
Back to all distractions.
It means he almost died. Really? There's 9 of you ganged up on it? 9?
Sure.
You see anything wrong with that?
Lot.
And this is all at 3:30 in the morning?
Yes, sir.
Is that right?
Yes, sir.
Nothing good happens at that time unless you're working. So you were 17 when this happened?
Yes, sir.
Is that right?
Yes, sir.
7 on October. You turned 18 2 months later?
Yes, sir.
That's all I would say. We'll take a look at the video on this in a minute.
Do you want to finish out the rest of the cases while we're waiting on that video?
What do we have?
Sylvester.
Just have a seat right over there, sir. And get that. Mitchell Sylvester.
Yeah.
That be it?
Yes, that would be it.
Mitchell Sylvester.
Thank you.
If you couldn't find it, I still.
Oh, gee.
I think he's rejecting the offer and Boyd says it's revoked now.
Come on up, sir. Thank you. You are Mr. Sylvester?
Yes, sir.
If you can stand right there, thank you. You are Mitchell Joseph Sylvester.
Yes.
And your attorney, Ms. Minaldi, is here, and the prosecutor is here. You are charged in 25 CR 307 with aggravated robbery, which, if convicted, carries with it no less than 5 nor more than 99 years confinement in prison or life imprisonment. And also you could be fined up to $10,000 as well. Do you understand what you were charged with here, sir, and what the punishment range is applicable?
Yes.
But under the law, the punishment range is based upon 2 basic principles: the circumstances of the crime and criminal history. And the indictment states you were convicted of an aggravated robbery out of the 252nd District Court of Jefferson County in 1980. After that was final, the next paragraph states, you then committed the felony of illegal possession of a controlled substance and were convicted in 1988 in this court for illegal possession of a controlled substance. And the indictment goes on to allege that after that 1988 conviction was final, you committed the offense of illegal possession of a controlled substance and were convicted of that in 1991 in the court next door. And after that 1991 conviction, 3 convictions in sequence, then it is alleged that on or about February 16th, 2025, you committed the current first-degree felony of aggravated robbery. If all of this was proven true, the prior convictions and this indictment, then your punishment range is not 5 to 99 or life imprisonment. It would be no less than 25 years, a minimum of 25 years. It starts off at 25 all the way up to life in prison. Do you understand what you're looking at in this case if found guilty? Serious. Okay, life, the rest of your life. I see you were born in 61. Well, 25 to life is pretty much does it out. Well, that's a substantial part of the rest of your natural lifetime. All right. Is there an offer pending here? Because rarely are these habitual, we call it habitual felony cases. Often they are worked out somehow without looking at a minimum of 25 to life. But what was?
Yes, Judge. So I had negotiated with Mr. Boyd to get a 20-year offer. So the offer would be 20 years TDC, which is less than the minimum that he would see at trial, but he is still electing for trial.
And you actually, because of the nature of the offense, you would have to perform at least 10 years before you're parolable.
That's correct.
But you could be parolable, subject to parole in 10 years of a sentence like this. But if it's 25 or more, that's 10 years will pass and you're going to be serving more time if you're convicted and sentenced to the minimum 25 up to life. So have you had a chance to really think real hard about it and talk to your attorney about the ins and outs about what your options are?
Well, she just came and see me the other day.
Okay. Well, I mean, did she talk to you about what options are?
She told me what my options were.
All right. Well, have you had enough time to think about it?
No, sir.
Well, how much time do you need to think about it? You and I are both getting older every minute. Well, how much time do you need to think? I mean, you've had to think about it since, when did you go see him?
Saw him yesterday, and then before that, I saw him a couple of weeks ago, maybe a month ago.
Okay. When was the offer presented to him?
The offer was originally 30, And I presented that offer to him and
And then you negotiated it down to,
That's correct. So he was presented with the 20-year offer to this morning. So it has been 30 and we've come down to 20 and he has not been aware of the 20-year offer until this morning.
okay. What's the state's position on this?
It's-
If it's not accepted.
It's Mr.
then-
Boyd's case, and he told me before he left to go upstairs to meet with a witness that if he rejected the 20 today, that the offer was 30.
The offer would be back to. Do you want to go in there and think about it a little longer? Because I've got another matter, but we're going to be finished. This is the last. Do you need any more time to think about it or not?
Yes, sir. Good.
Well, you had to be thinking about it since this occurred and you were arrested, huh? In February, right? April, May, June, 4 months. But how much time do you need to think about it? Because they're giving you kind of a deadline here, it looks like.
I need another month or two.
Sir?
Month or two.
A month? I don't think that's gonna be in the game. That's not what they're saying.
I was told he has today, and I don't really have the authority to, go beyond that. It's not my case.
Any input from the defense?
I mean, I think that
It's his life. It's his life, and everybody in here, you and as well as me, we all have decisions that are ours to make. And it sounds like you've been informed of what your options were. You understand what the options are. You don't have many options here. You can certainly, and you're presumed innocent. That's the way the law is. You hadn't been found guilty of the crime. If you were found guilty, the way it sits, you're looking at a minimum of 25 years up to life in prison. But that's, you were there, you know what's best, what the facts are, but the state has their position and they're saying that if you don't accept the deal now, then it's revoked. And the only other option is we set it on for trial and you don't get the deal, you're looking at a minimum of 25. So I don't know, it's your call. But you don't have months to think about it. You've had to have been thinking since February 16th about what potential options might happen. So I know but everybody in this room has the same dilemma. They have to decide what. Nobody can make the choice but the defendant. Him, you, me, when I make choices that are mine, and people can give you input. Yeah. But it's your choice at the end of the day. What do you want to do?
Either way it go, I'm doomed. You gotta take 25, 20 or 30, either way it go. I'm not coming back to the world.
Sir, I'm older than you are. And I hope to live a lot longer.
I hope
but you too will. I'm pulling for you. But what I'm saying is that in 10 more years,
probably could.
You're not that old. I mean, you're thinking that, but it's your choice. I'd want
Judge
something other than incarceration the rest of you. But in 10 years, you still have, I think the average lifespan is more than that of 10 years, but maybe you're just not as hopeful as I am.
Given that I just received the re-offer of 20 years today, and he has a very big decision to make, could we request for a 1-week resetting to give him time to think on that?
Well, I can't. The district attorney's office.
I will just, for purposes of kind of what I've seen here, hold it open or ask Mr. Boyd to hold it open until that 1 week when he comes
They're
back.
gonna give you a week to think about it.
But
That's more than fair.
after that, it's over.
Is that good for you to think about? All right, why don't we reset that 1 week? Okay. and we'll bring you back next Monday and we'll see what happens.
Yes.
Okay. And feel free to talk to this lady so she can answer any questions that you might have to make this decision easier to make and the proper one in your situation. Okay. All right, thank you. Yes, sir. On Mr. Simon?
I have the
Okay.
video, Judge.
Just to make sure, we already did Kenneth Randolph and all those.
I don't have anything else.
Okay. There, so you don't have any others?
No.
Okay.
Just some.
David,
Thank you.
here's David Grove's cases from the other day on Katie Knight.
That's right, it's right.
It's right. He said he's gonna be here at 1.
Okay, it was David's, now it's Rives. Okay, they'll be here at 1, okay. All right, let's, first of all, where is the defendant in this? Do we know?
I was getting this copy, Judge. I was able to determine that. I'm gonna play that, identified, stop and identify.
Thank you.
Since I'm doing that, Your Honor, I'm gonna go ahead and mark this exhibit as State's Exhibit 2, since the plea is State's Exhibit 1.
All right, any objection? Without objection, it is so marked. Thank you.
So if you give me a little latitude, Judge, I'm gonna play this and then pause it. By way of comment, he is supposed to be wearing a white shirt, green shorts.
If we can.
This here is the victim. Where the pointer is, that's Mr. Jefferson.
Who is the victim here?
I believe that this is Mr. Simon right here.
Where?
Right here where my pointer.
I'm sorry, I don't see the pointer. Okay, all right.
I'm gonna back
This
up,
back to us?
see his
Yes.
face?
Okay.
See the face there?
Mm-hmm.
That is Mr. Simon. When the car moves away, you're gonna see that he's wearing the green shorts as described in the PSI. I'm gonna pause it where it's clear that the gun is in his left hand. When the car moves at this stage, Judge, and if you pay attention, this is Mr. Simon here, where the pointer is. So you got already? I stopped it.
There's something.
Point you to
Left hand.
You see the gun in his left hand. He's holding it down as the car is moving away. The assault is about to occur. You see him getting in his licks there, Judge?
Man, stop.
Okay, good. Bring that back to the punching, please, if you.
Yes, sir. And sticks that gun in his shorts right there. And delivers by my count at least 6 hits on the victim.
It's okay. We'll bring it back, right where he's in front of, in the foreground of the camera. Stop.
Where do you want?
As he's walking right around the right fender. Stop. Okay.
See how he's holding his hand? Like he's dealing with the gun there in his pocket? This is- Have you seen enough, Your Honor, or do you want to see more?
I want to go back to the beginning of this assault, please.
Where, do you want the portion where we see the gun in his hand?
Yeah, the beginning, and
Yes, sir.
then how he's at the point where the court is moving.
You want to do the VLC and zoom in?
No.
Yeah, can you zoom? Do you have the ability to zoom?
I do whenever I ask for help.
No, thanks. Probation?
Yes, sir.
Is, hold on for just a second. You can stop that.
versus Ronald Pitaway. 2502023. Who's Donald? Who's Ronald? Come on up here.
We're both down.
Your name, sir?
He's Donald Pitaway Senior, I'm Donald Pitaway Junior.
Well, who's the plaintiff? I can't even tell.
Me, but my father was the homeowner and stuff, and we had a discussion about that last time we were here in court.
Wait a minute. Who filed the claim?
I did.
You can't do that. Didn't I tell you that? Did I not tell you that?
Tell me.
Did I not tell you that?
Yeah, you said something about, well, you're not the homeowner.
Well, and so I adjourned it. You got to get a lawyer to handle this for you, sir.
I did.
It's not for you, it's for him.
I did wind up contacting an attorney. I don't have I can't meet with him until June 30th.
Your name?
Ronald Pitaway.
Who owns this home? You own this home? Yes? I can't hear you.
Yes.
And you're Donald Pitaway Senior, right?
Yes.
And where's the property? On Maple Lane?
No, 2067 on Churchill Avenue.
Why?
The Maple Lane is where he lives.
That's not where I live, my address is.
The property that we're talking about here, is it for Churchill Avenue? Is it for?
Yes. Yes.
That's where we live, Churchill.
Do you live there?
That's my residence, yes. It's on my driver's license. I live there, my property's there.
Mr. Patterson's talked to yet is Trinity Sutton.
Well, that one that you said was pro se, I show attorney William Wilson or Matthew William Wilson.
Yes, Your Honor. He is unfortunately out today, so I'm standing in for him.
Okay, so he's not pro se. Very well. Okay.
Okay.
Counsel, are we ready to go back to Mr. Hillman?
Yes, Your Honor.
Very well. We are on the record in 2023 TR 1052, State of Kansas versus Edward E. Hillman. Please announce appearances.
Jared Regier on behalf of the state.
Your Honor, Darren Patterson appear on behalf of Mr. Hillman. Mr. Hillman does personally appear from Courthouse Security 1 video station. Judge, this is a warrant to show cause. I would tell the court I have reviewed that warrant to show cause with my client. He is going to stipulate that he did fail to pay and fail to report. And upon the court accepting his stipulation waiver of hearing, there are agreed to recommendations. Those are that he received credit for time served. He did 28 days on this warrant to show cause before bonding out. That would be considered the sanction, and the recommendation then would be placed back on for 1 year reporting probation. And Mr. Hillman is asking that probation consider transfer to Sedgwick County if that can be done and worked out. Otherwise, he stated he would comply with whatever directions Mr. Smith provides him.
Is Sedgwick County his home county?
Yes.
Mr. Regier, you're in agreement with those recommendations?
Your Honor, upon successful acceptance by the court of a stipulation in this matter, the state is prepared to recommend credit for time served and that reporting probation be extended for a period of 12 months for today's date. This does appear to be a case where an appearance bond was executed on May 9th of 2025, subsequent to a first appearance on the request for revocation before Judge Hart on April 14th of this year. That is the basis of the recommendation. The state's understanding is that the issue of courtesy supervision to another county was not specifically discussed during plea negotiations. However, if those are the orders of the court, the state does not oppose proceeding in that fashion.
Mr. Hillman, you've gone over this warrant to show cause why your probation should not be revoked with your attorney.
Yes.
You have everything to lose
And
by
does he speak correctly for you?
misstating
when
the
He
facts.
says that you're
Everything
waiving
to
your
lose
right to a
when
hearing on
we find,
this.
especially when we learn
You know, you
from the
do have the
video
right
here
to make the
that
state
that was
try to
wrong,
prove these
flat wrong.
violations.
Yes.
So when it states your version, I did
If
not
you
have a
believe
weapon, but
that
other
if
people did
we
have
went to
guns.
hearing on
That was
those
wrong. You looked me right in the
allegations
eye
that
and
they
lied to
could
me.
prove that you violated
And
your probation.
That's not the
Yes,
way to
ma'am.
handle it. And we don't have to be
And
up
you are
here
stipulating or agreeing that you did
showing
not
you that
report
you're
as
not telling the
directed, pay
truth
as
for you to tell
directed,
me the truth.
or gain or
You need
maintain
to be honest
employment all the time.
from the get,
That's
from
correct.
the beginning of this.
Anyone making you waive your
What
right to
this
hearing or making you enter
is
these stipulations?
multi-level state of problems in this town, in this county,
Then I
that
will
is
find that
struggling
you are knowingly and
with
voluntarily waiving your
misbehavior,
right to hearing and have stipulated
with the
to
16th highest
the
crime rate in the
alleged
state.
violations.
There's nothing that we're
Therefore, I
proud
find
about.
that you
And the
are in
people
violation
who are
of your
trying to be proud
probation.
in the
I
city and
do
do the right
revoke your
things
probation,
are having to
but
deal with
I
irresponsible
will
behavior.
order that
This
it
is
be
occurring at
reinstated
a
after
public
you have
place, a
served
grocery store
the
at 3:30 in the
28-day jail sanction. I will give you credit for any time served, and you are to report immediately to probation upon completion of those 28 days. And if that is now, then you need to report directly to court services.
Okay.
As far as whether it can transfer to Sedgwick County, I will ask you, Mr. Smith, do you know of any reason why it shouldn't be?
No, Your Honor, that was going to be my intent originally. However, he never reported in person at all to get the paperwork and all the other things completed, so he could get that accomplished.
Well, Mr. Hillman, you better get everything accomplished this time around.
It'd be a lot easier to do it from Sedgwick County, that's for sure.
Well, you better get it done, whether it's in Butler, whether it's in Sedgwick, because a second time in front of the court, you'll most likely just serve your time regardless of the recommendations, because the court does not have to accept recommendations.
Understood.
All right. So you've kind of had two bites at the apple, as they say, for probation. Third time, I think. Well, third time is not going to be a charm. All right, if there's nothing further, we'll be in recess. Mr. Hillman is excused.
Your Honor, there is one final matter.
Go
Your
ahead.
Honor, pursuant to plea negotiations, the state was recommending a 12-month extension of the reporting probation
yes.
in this case.
Yes, absolutely. Probation is extended for 12 months, 1 year from today.
Thank you, Your Honor.
You're welcome. Mr. Smith, are you here for any other cases today?
No, Your Honor, I believe it's the only one on the docket.
Well, thank you. You are excused, as is Mr. Hillman. You're welcome. Mr. Hillman, check in with court services immediately, see what they want you to do. Unless, Mr. Smith, you've already told him.
No, Your Honor, he will need to report.
All right, you go down and report right now. That is the order of the court.
Okay.
All right, you may go. Let's see, Deputy Patterson, you have someone at the county jail that I did not have on my docket. Perhaps you even were instrumental in getting it here. A Dunlap, Casey Dunlap, are you familiar with that?
Judge, I had Casey Dunlap down as a motion for judgment on bond filed and set for today. So I knew that she was in jail, so I just wanted to have her present for that. Now, if that's been withdrawn, I wasn't aware of that, but I would also just want to take up the case. I'd sent Mr. Regier just a little bit ago an email with proposed resolution to the case rather than have her sit in jail till July or August. I'm not sure when her next court date was set.
Jen, you told me a while ago. What was it? Someone told me.
It was set for July 18th and the withdrawal was done on June 11th.
Well, so you've made a proposal to Mr. Regier. Mr. Regier, have you seen that proposal?
Your Honor, I will need a minute of the court's time.
All right, go ahead.
Judge, what was the case number on Casey Dunlap?
2024 TR 870.
I'm sorry, somebody started talking in my ear about the time you were given the last numbers.
870.
Okay, thank you.
You're welcome.
Judge, can I interrupt for just a second?
Yes.
Charlene Smith, you need to mute your phone because we can hear you when you're drinking your drink.
Don't you love it? I do that every now and then myself.
And Your Honor, what I would tell the court is previously it would appear an order withdrawing motion for judgment on bond was filed with the court within the last week. The state is prepared to proceed in this matter. I am showing that previously there had been a first appearance before Judge Hart on June 6th, and the matter was set over to July 18th with Judge Lee. However, this is a case that does appear to have a certain degree of age to it, although certainly not the oldest case this court has ever seen. For purposes of timely resolution, the state is not opposed to proceeding in this matter today.
Based upon that, Your Honor, I would make the following announcement that Ms. Dunlap would be entered a plea of guilty to driving while suspended, Class B non-person misdemeanor, and the state has agreed to dismiss speeding.
Mr. Regier, is that correct?
That would be the state's anticipated resolution in this matter, Your Honor.
Miss Dunlap, have you been hearing everything that has been said so far?
Yes, Your Honor.
And do you agree with the negotiations and recommendations that are being made?
Yes, Your Honor.
At this time, then, how do you plead to count one, driving while your license was canceled, suspended, or revoked?
Guilty.
With
And
all
are
due
you
respect, with all due respect, Your Honor, the ticket in this matter appears to list count 2 as driving while suspended under KSA 8262.
Well, when it was entered into the computer, count 1 was put the other way around. Let me look specifically at the document that you're referring. Okay, citation was filed March 22nd, 2024. Speeding count 1 and count 2 driving while suspended. I don't see any amendments. How is it, Jen, that it gets put in the computer differently?
That is not our office that puts it into the computer. I believe that would be the county attorney's office.
All right, so will we need anything changed? Can the clerk change that since they put the charges in backwards?
I believe that would take an amended information.
Well, and if it does, it does. I was just wondering, like you said, the charging document has it right, but whoever entered it has it backwards, so.
And Your Honor, this does appear to be a ticket by the Kansas Highway Patrol. The state would anticipate filing unamended information to account for in the negotiated plea deal in this case. So I'm not sure if that allays the court's concerns at this time or not.
Sounds like it will, thank you. All right, so back to you, Miss Dunlap. How do you plead to count 2 driving while suspended? It's just a technicality, whether it's count 1 or 2.
Okay, guilty.
Okay, yeah, I'm not trying to trick you or add a new charge.
Okay.
Okay, so to driving while suspended, you're pleading guilty, and is anyone making you do this other than, maybe through the plea agreement, they're giving you an offer?
No.
Okay, no one's threatening you?
No.
Okay, and no promises other than the plea agreement?
No, Your Honor.
Okay. Do you understand that with this plea, you're giving up your trial rights and you'll be found guilty and unable to appeal?
Yes.
Okay, and so this is what you want to do, plead guilty. And were you in fact driving while suspended on March 22nd, 2024 in Butler County?
Yes.
Do you remember where you were when the officer encountered you driving while suspended?
I was somewhere on the turnpike. I don't know exactly where for sure.
If he says you were driving on the Kansas Turnpike I-35 at mile marker 95 north, you wouldn't object to that mile marker?
No.
All right. Well, I know mile marker 95 is in Butler County, but Mr. Aguirre, you probably know exactly where that is.
Your Honor, it would appear that mile marker 95 is in the northeastern quadrant of Butler County. Although close to the county border, the state's evidence would show where this case proceeded to trial that mile marker 95 on the Kansas Turnpike is still within Butler County boundaries.
All right, thank you. So I find the defendant knowingly and voluntarily entering the plea and the court having jurisdiction, the defendant is found guilty of count 2 or count 1, which now I'm confused.
Count 2 of the ticket is driving while suspended, and that is what is contemplated by the plea agreement, Your Honor.
All right, and with the defendant being found guilty, recommendations?
Your Honor, pursuant to plea negotiations, the state is prepared to recommend the statutory minimum fine of $100, court costs, that the court make a determination on an appropriate amount of attorney's fees, an underlying sentence of 120 days and 6 months of non-reporting probation.
How much has she served already?
Judge, she has been in jail since June 5th.
And Your Honor, I am showing first appearance before Judge Hart was conducted on June 6th, and the defendant, based off my notes, appeared in the same fashion that she does today.
Miss Dunlap, do you work when you're not in custody?
I do, yeah.
Where do you work?
I work at a pizza place in Mulvane.
Do you think that job will be waiting for you when released?
Yes.
And is this a full-time job you have?
Yep.
At least 40 hours a week?
Yes.
Okay. At this time, your sentence will be 120 days. Credit for time served. You will get a non-reporting probation of 6 months. So for the next 6 months, you're on probation.
Okay.
If it's revoked, you could go back to jail for the balance. The conditions to keep it from being revoked are just 2 conditions. 1, don't violate any laws for the next 6 months, and 2, pay all fines and costs. Those include $100 in fines, $108 in court costs, and I will have you pay $250 towards your court-appointed attorney fees for a total of 458 days. How much time would you need to get that paid?
A month.
30 days? Very well. I'll order that you pay that within 30 days. Again, if it's not paid, you could get your probation revoked, or you could get your license further suspended, or you could get this turned over to a collection agent. So be mindful of that. Also be mindful if you get another driving while suspended, there is some mandatory jail time again on that.
Okay, Your Honor.
All right. Anything further, Mr. Patterson?
No, Your Honor.
Mr. Regier?
No, Your Honor.
Very well. Ms. Dunlap, you are excused from this case at this time.
Thank you, Your Honor.
Your
You're
Honor,
welcome.
is she released on probation then?
She is,
Okay,
with the conditions that I gave her, yes.
thank you very much.
You're welcome.
You have
Can make those
everything to
payments?
lose by just misstating the facts. Everything to lose when we find, especially when we learn from the video here that that was wrong, flat wrong. So when it states your version, I did not have a weapon, but other people did have guns, that was wrong. You looked me right in the eye and lied to me. And that's not the way to handle it. And we don't have to be up here showing you that you're not telling the truth for you to tell me the truth. You need to be honest from the beginning of this. What this is multi-level state of problems in this town, in this county, that is struggling with misbehavior, with the 16th highest crime rate in the state. There's nothing that we're proud about, and the people who are trying to be proud in the city and do the right things are having to deal with irresponsible behavior. This is occurring at a public place, a grocery store, at 3:30 in the morning. Everybody needs to be in bed or working, not messing around in a congregation of folks and then assaulting. And there was y'all attacked the guy like a pack of wolves. It's like a pack of wolves. And then anyone who has a firearm, anyone who is displaying or exhibiting a firearm is only going to throw gas on the fire. Because somebody sees this, it's when you pull it out, you're using it. And you're either going to use it for the wrong reason, or someone's going to shoot you. But when you pull out a weapon, the people are submissive and you have the power over them, which you're not supposed to have. That's not the right thing. And then y'all all pounced on the victim, and there's no way he can defend himself. It's just not fair. It's just not fair. It's like playing on a basketball court and the other team shows up with 20 players and you're stuck with 5. It's not right. It's not fair. That's why sports, which emulates real life, good lessons with rules of behavior, are followed. And when you don't follow the rules, then you get it's a foul and you get punished. And same is in real life here. There are too many aggravating factors here that all add up to problems. But when you are rightfully accused, you don't lie like you did. Others have been forthcoming. And it's not as though you haven't had problems in the past. I mean, I'm looking at putting the city ordinance in the runaway. I've got evading arrest out of Harris County that was dealt with through the court. Unauthorized use of a motor vehicle that was, I think, dealt with in this county under juvenile matters. And then evading arrest with a motor vehicle. The point is, juveniles, people make mistakes. When you're young, you're supposed to learn from these mistakes and do better. And then after all of those situations that you had with court authorities, then on October 1st of 2023, after all of that, mistakes have consequences and you were dealt with them. And the right thing would, of course, learn from those mistakes. But here we are at 3:30 in the morning and you're displaying a gun. And whether you fire the gun or not, it emboldens the person carrying the weapon, and it is not fair to others or being subject to the misuse of the weapon, like the victim in this case. They do not have their rights anymore because they are submissive, thinking they're about to lose their life, which is what happens when you brandish a gun. People are going to assume that death is a clock's tick away, and you're not supposed to have that power over other people. But all that being said, with all of those priors, then you get here and you lie. And we have to see the video. I wish you would have handled this a lot better and more honestly. Anything else to add? If not, I'm going to find you have pleaded guilty in this case, Mr. Simon, voluntarily, knowingly, intelligently. There was sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here in this earlier plea hearing to find you guilty beyond a reasonable doubt. Before I move forward here, is there anything else you would like to add?
Yes, sir.
Yes, sir. Go ahead.
Apologize for lying, possibly saying that I didn't have a weapon. Just I was misunderstood it. What did I use it? I have it. That's all.
You told the probation officer, I did not have a weapon, but other people had guns. They don't lie. They wrote down exactly what you told me. And that's what you told me. We had to prove otherwise. Anything else?
Sure.
I hereby find you guilty beyond a reasonable doubt of this second-degree felony of aggravated assault with a deadly weapon. I'm following this agreement. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 10 years. The judgment shall reflect an affirmative finding that a deadly weapon, namely a firearm, was used or exhibited in the commission of this offense. Do you understand what has happened today, sir? You will be given credit for all time you have served. Anything else?
No, sir.
That is all. I am really disappointed that this one worked out this way. I thought that you were going to handle this a lot better. That is all. We are in recess. Thank you.
perfectly fine. Like, love it, love it, love it. Can I ask why?